Your Lordship,
mentioned for hearing.
Group 8 matters.
Group 6.
Group 6.
Yes.
Your Lordship, may I mention a matter? It's a matter assigned to Your Lordship. It's a civil revisional application. I'm mentioning for inclusion in the list. Has not been included.
Was it assigned? Civil revision?
Yes, Your Lordship. I've attached the assignment order as well with the mentioning slip. Your Lordship will find it at the last page.
My lord, record is check.
Monday to mention.
Grateful.
My lord, I beg to mention, my lord, one restoration application, my lord.
Restoration application.
Restoration application.
My lord, may I mention this matter? It's a group 6 matter. Hindustan Cables, its officers association,
2018 to 21.
2018.
18. Restoration application.
No, for hearing.
For hearing. For hearing.
Officer.
Lordship, may I permit to mention? Group
Yes.
6 matter for here.
Okay, call the list.
Yes, my lord. Yesterday I completed my submission as submitted that one judgment regarding the regarding the scope and ambit of interference on behalf of the writ court in tender matters, my lord. It's just this judgment. Apart from that, I will have nothing to submit, my lord. I have already completed my submission, my lord. This is reported in 2016, volume 16, Supreme Court cases 818.
Yes.
Yes, straight away, paragraph 14, my lord. Paragraph 11 at internal page 7, paragraph 11. Lordship has got the paragraph 11.
Yes.
Recently in Central Coalfields Limited versus SLL SML, it was held by this court relying on a host of decisions that the decision-making process of the employer or owner of the project in accepting or rejecting the bid of a tenderer should not be interfered with. Interference is permissible only if the decision-making process is mala fide or is intended to favor someone. Similarly, the decision should not be interfered with unless the decision is so arbitrary or irrational that the court could say that the decision is one which no responsible authority acting reasonably and in accordance with law would have reached. In other words, the decision-making process or the decision should be perverse and not merely faulty or incorrect or erroneous.
Yes.
No such extreme case has been made out such. Thereafter, my lord, in Dwarkadas versus such and such, it was held that the constitutional courts are concerned with the decision-making process. Tata Cellular versus Union of India went a step further and held that a decision, if challenged, the constitutional courts can interfere if the decision is perverse. However, the constitutional courts are expected to exercise restraint in interfering with the administrative decision and ought not to substitute its view for that of the administrative authority. This was confirmed by such and such. Paragraph 13. In other words, a mere disagreement with the decision-making process or the decision of the administrative authority is no reason for a constitutional court to interfere. The threshold of mala fide, intention to favor someone, or arbitrariness, irrationality, or perversity must be met before the constitutional court interferes with the decision-making process or the decision. Paragraph 14. We must reiterate the words of caution that this court has stated right from the time when yesterday I mentioned Ramanna Dayaram Shetty versus International Airport Authority was decided almost 40 years ago, namely that the words used in the tender documents cannot be ignored or treated as redundant or superfluous. They must be given meaning and their necessary significance In this context, the words that is not necessary. Paragraph 15, the most important, that is all. We may add that the owner or employer of a project having authored the tender documents is the best person to understand and appreciate its requirements and interpret its documents. These particular 3 lines are most important in interpreting. The constitutional courts must defer to this understanding and appreciation of the tender documents unless there is malafide or perversity in the understanding or appreciation or in the application of the terms of the tender conditions. It is possible that the owner or employer of a project may give an interpretation to the tender documents that is not acceptable to the constitutional courts, but that by itself is not a reason for that's all.
Also, so for the reply is concerned, also I'm praying for that's next week. Also, I give the reply. That's
Next
what
week.
I taken all points. Also, submission of my learned senior friend. Next week I'll give.
So far as factual aspect is concerned, my lord, should not be allowed. But so far as legal,
Obviously, so the factually they have some given wrong information.
Very well. 28th.
28. And also, I will deal with this judgment also.
Very well. Argument on behalf of the IOCL concludes. Let the matter fixed on 28 under the same heading.
Great.
And for the statement or for the private respondents.
My 2 esteemed learned friend representing one private respondent and the state, Mr. Galib and Mr. Suman Sengupta.
Yes.
So far the submission on behalf of the private respondent, I am giving reply first. Mr. Galib. His first submission was relying on Article 226, subclause 3 of the Constitution of India, that for some time enjoyment of the interim order, automatically it will be vacated. In this case, what happened, my lord? They filed a vacating application.
Okay.
They have not placed the vacating application before the coordinate bench. You will also kindly see one order passed by Justice Coordinate Bench on 28th of March 2024. Justice Portnoy. 28th March 2024. May I hand over? That is also in the file. But I'm reading from top. This is an order of 28th March 2024. Affidavit of service filed on behalf of the applicant respondent number 6, that's my learned client, is taken on record. Mr. Kamalesh Bhattacharya, at that material point of time, Mr. Bhattacharya has been briefed on behalf of the private respondent. Learned advocate for the applicant respondent number 6 submits that his client will not file affidavit in opposition to the writ petition. Rather, application for vacating interim order can number so and so be treated as affidavit in opposition to the writ petition. I'll take note of this.
Yes.
They did not choose to move their application for vacating interim order. They sought for final hearing by saying the court, this application may be treated as affidavit in opposition. And accordingly,
Yes.
the court accepted such submission, allowed them not to file opposition and treat the application for as in opposition. You will also kindly go through the next paragraph. Mr. So-and-so, learned advocate for the petitioner, seeks to file in opposition to the vacating application. He further submits that the report submitted by the state respondents is incomplete in the extent that there was specific direction of the court to so and so. Mr. Amral Chatterjee, learned advocate for the state 6 to file supplementary report. Kindly see, in the form of affidavit annexing the first report, it is expressed so and so. State respondent is direct to Mr. Supplementary report of the affidavit annexing to the inquiry report, dated so and so, application so and so, advance copy so and so, exception so and so. So, accordingly, court passed an order for filing, exchanging of affidavit on their pair. Today, they are saying that Article 226, subclause 3 says, after some time, interim order automatically vacate, although not mandatory. But fact remains they did not choose to move their application for vacating interim order.
Yes.
The next course of submission of Mr. Galip representing the private respondent was relying on third report, page 4. People also kindly take up the third report that has been affirmed on 19th June 2024.
Yes.
Page 4 they have relied on. Rely on the page 4 saying that his client got higher marks. You will also kindly see first column, that is the report of the inquiring personnel. Deepak Kumar Singh, that's a private respondent, got 71. My client got 69, admitted. Now the 4 columns, next 4 columns is more important. All the members of the selection committee, 3 members, district level fair price shop selection committee, who are the higher authority, total awarded 25 marks by them. What they have done, my lord? They have given 0, 0, and 0. So far, the private respondent. Why? Because he is not an eligible candidate. The rule says the district level sub-selection committee's duty is to consider the candidature of only eligible candidates. Chapter closed there. The moment inquiring team submitted a report through subdivisional controller, fixing some of the candidates as eligible and some are ineligible, with the instruction, rather request or advice to take note of the candidature of the eligible candidates and submit a report so that it can be forwarded to the director level through the district controller. Kindly see the signature of the bottom portion. Who are the members? First, ADM, Food. First, my lord, Dinajpur. Then, District Controller Food and Supplies, Uttar Dinajpur. Then, Subdivisional Controller Food and Supplies, Islampur. Out of these 3 officials, District Controller Food and Supplies, Subdivisional Controller Food and Supplies are the Food and Supplies Department. So far, the ADM is concerned, he is not a officials of the Food and Supplies Department. Kindly take note again, my lord, the remarks column. Ineligible, go down is closed, 3 foot lower, almost, go down is almost 3 foot lower than the road level. So, my lord, according to my understanding, so far the candidature of the private respondent is concerned, it cannot be reopened at any time by even the ballot committee. I shall show from the rules, statutory rules, what is the power, what is the authority of the district level sub-selection committee, whether they can do anything beyond the scope of statute. Even my lord, inquiring committee. Now,
all ineligible got 0, 0, 0. যত ineligible ছিল সবাইকে 0, 0 দিয়েছি, কিন্তু শুধু ওকে নয়। PL number 2.
Well, a pertinent question has been fallen from your lordship on the last occasion. That the private respondent is not only the ineligible candidate, there are other ineligible candidates. Kindly see, all those ineligible candidates has been given 0, 0, 0. And I have the only person who has been given more marks up to 83. If you actually kindly see serial number 4, he is also eligible candidate. And accordingly, district level sub-selection committee awarded marks also to him. The question was fallen from your lordship, then why this selection of a particular candidate for re-inquiry? That has not been answered to. Now, your lordship, kindly say, I have already shown, I shall not go to what this document is concerned. Who has done it? Officer in charge food has been instructed to conduct a personal inquiry by the ADM food. After decision taken, sign has been done by 3 members of the district level sub-selection committee, an individual without any deliberation, without any consideration, without any decision of the committee, personally took a decision that there should be a fresh inquiry by his personnel, not the personnel of the food and supplies department. I can see I can show my lordship that he is a third party out of any selection process.
Yes.
Now, what happened, my lord, after that? The very gentleman, who is not at all an official of the food and supplies department, conducted a fresh inquiry. That will appear from page 3, just earlier page.
Yes.
I personally visited the site along with inspector. Take note of this, my lord. A outsider having role to play in the selection process as per instruction of a particular officer of outside food and supplies department conducted personal inquiry. There is no statute, there is nothing in the any statute that a person can take a thing personally. No statute permits it. This is not a case of personality. He is not a private individual. Now, my lord, this inquiry has been conducted, then report has been submitted. The second point argued on behalf of the private respondent that higher marks have been awarded. Sorry, my lord. The next argument was placed before your lordship that since all the members have been empowered to award separate marks. Sorry, my lord. The next argument on behalf of the private respondent, which has been fallen from your lordship actually, the whether committee has the power to re-inquire. I can show to your lordship, my learned friend has tried to satisfy your lordship. And ultimately, as I understood, Mr. Galib has submitted before your lordship that statute does not at least permit it for re-inquiry. He has submitted on question of the court that at least statute there is no provision for re-inquiry.
You have not said that you silent that cannot.
Yes.
And he cannot be, both are silent.
Yes.
Statute.
Yes.
Yes.
Towards the rule. Says, as you said, rule does not say cannot do it.
The question was whether there is any provision under the control order or any circular. Re-inquiry can be done at the instance of the district level sub-selection committee. Answer is under the law, control order never permits it.
Yes.
Now it has been sought to be enlarged before your lordship. What is the submission? If the statute is silent, in that case, a statutory authority can go beyond the statute. My respectful submission before your lordship, there is a great no. Why I am submitting the so? Your lordship knows this is a settled principle. No judgment is required to be placed. A private individual can do whatever he like within the law.
Yes.
But a statutory authority can only perform his job what he has been given to do. A statute is very specific. What is your duty? What is your responsibility? You can do only that thing, not beyond the scope of statute. Otherwise, there will be a chaos. The Supreme Court says even a higher authority cannot assume the power of a lower subordinate authority. It is a settled principle. Otherwise, just I am giving an example. Your Lordship knows, so far the control order is concerned, subdivisional controller is the licensing authority. So far the fair price shop is concerned. And the district controller is the appellate authority. A complaint has been lodged with the district controller. This particular dealer is not delivering the goods to the consumers. I am one of the consumer. Please look into the matter. What can do by the district controller? He only can do send this document complaint to the subdivisional controller.
Yes.
Please look into the matter. Please look into the matter. Even he cannot say initiate a proceeding because that will be a dictation. Supreme Court thousands times says on the basis of dictation, if any order is passed, this is bad in law. So power has been vested to a statutory authority under the statute. You have to perform within the periphery of that statute. Alone, you cannot enlarge your power by saying that since the statute is silent, I am taking this part.
Yes.
If the district controller thinks, so far the example I am just given to your Lordship, issue a show cause notice, and I am the higher authority, I shall terminate your license. Fact remains, you are not delivering the goods, I am terminating. Then what will be happen? Under the law, he is the appellate authority. The person concerned whose license has been terminated, he cannot enjoy the first appellate forum.
Yes.
For that, always statute says the statutory authority cannot go beyond the scope and four corners of the statute. So argument which has been sought to be advanced, that if the statute is silent, I can venture beyond the scope of statute. Possibly, my lord, there is no leg to stand. The next course of submission, my learned friend relied upon the circular dated 17th August 2023, which I have also placed before Lordship. Lordship, kindly take just for a moment and saying that this cannot overrule the statutory control order. 17th August 2021. But before going through this circular, if you Lordship kindly take up clause 20 Roman 4A at page, my lord, 1.20. Roman 4A.
Yes.
What I am reading. For the purpose of choosing the most suitable candidate, the state government may, by an order, constitute district level fair price shop selection committee and shall also devise a marking system covering the size of godown, accessibility of the shop from main road, area of location of shop, etc. in the manner specified in the said order. So, what power has been given to the authority to frame rule how and which manner selection process will be conducted for selection of fair price shop. Now, your Lordship kindly take up the circular. My learned friend says that it is a mere circular, it cannot override the statutory provision, that is the control order. Kindly see 17th August 2021. First paragraph I am reading. Whereas the selection against the new and resultant vacancy of the fair price shop dealer is being made under the West Bengal Public Distribution System Maintenance and Control Order as per the procedure laid down in the two control order. And whereas the state government has decided to devise a procedure of making a marking system for selection of fair price shop dealer as well as to constitute a district level fair price shop selection committee in the every district for the purpose of selection of fair price shop dealer in just and transparent manner. Now, therefore, the governor is in pursuance of the clause 20 of the West Bengal Public Distribution System Maintenance and Control Order and clause 17 of the West Bengal Urban Public Distribution Control Act 2013 do whereby please to devise the following procedure of inquiry of selection of fair pillars. Is that no, my lord, statutory force? This is statutory circular. As per power, the source of power is the control order.
Yes.
Control order has been framed under Section 3 of the Essential Commodities Act, read with Section Control Order 2001. And this power has been exercised by the state government as a delegate in exercise of the power under Section 3 of the Essential Commodities Act, read with Control Order 2001. Then, my lord, there shall be no sport-based, then kindly turn to paragraph 2. Concerned subdivision control of food and supplies, very important, my lord, or rationing officer in the urban areas shall conduct inquiry either personally or through officer or officers. Office who shall assess the infrastructural criteria as stipulated in the control order, as well in the vacancy notification and so on. So who can conduct the inquiry? Either subdivisional controller or he will deputy a person. Does it appear from that document that subdivision controller ever asks the food officer, officer of the district magistrate? The statute, none other than the food officials and the subdivisional controller can conduct any inquiry. Question of re-inquiry will come later on. Subdivisional controller is the only authority to decide whether he will do it or he will deputy a person of his office, not for the office of the district magistrate. Next paragraph, kindly see, my lord, marks have been given. Then 3. The concerned subdivisional controller or rationing officer shall submit the report to the concerned district controller food and supplies within the stipulated time. Procedure. The inquiry officer, after conducting inquiry of the food and supplies office, shall submit the report to the subdivisional controller. What will be the duty of the subdivisional controller? He will submit it to the district controller. Then, before sending the report to the district distribution, procurement and supply through the district magistrate, the district controller food and supply shall place the matter before the district level fair price shop selection committee, constituted for the purpose of comprising the following officials. Who are the officers? Additional district magistrate of the district controller and subdivisional controller.
Yes.
But it has been done. They have decided this is the gentleman who will be appointed. His name should be recommended to the director of district distribution, procurement and supply. He is the most suitable. After taking decision, one of the members decided, no, he is not my person. I shall send a person from my office and he will conduct a report. He will submit a report in favor of the private respondent so that we can select him. Now, your lordship, kindly see the next paragraph. Each member of the district level fair price shop selection committee shall evaluate the applicant on the scale of 0 to 25 to determine the suitability of a candidate from among the eligible applicants. Nothing remains. The moment a candidate has been notified, he is not eligible, district level shop selection committee has no role to play. Only eligible candidate. Kindly see, once again I am reading. Each member of the district level fair price shop selection committee shall evaluate the applicant on the scale of 0.25 to determine the suitability of a candidate from among the eligible applicants. How can they determine whether he is a good or bad after declaration of ineligible candidate? The next paragraph. The average of marks received by the applicant shall be the gross marks secured by the district level. If consideration necessary, take personal interview of the so. It does not ever says that you may conduct a fresh inquiry. District level subsidiary make a recommendation on the basis of the total marks of the marks given by the committee. District level subcommittee will giving the so. These are the provisions. So this is statutory circular. Power has been vested to the state government to constitute a committee, and which manner this committee will perform their duty, and who will be the members of that committee. An individual has no right to play. ADM cannot touch with the decision of the district level committee. This is a composite decision after deliberation, consultation. He is the best candidate, and you have already declared ineligible. Then the next course of submission on behalf of the private respondent. Part 2, clause 4 has been placed before your lordship. That is page 22 of the writ petition. তাই তো এটা তো এটা দেখ এটা দেখ না এটা তো দেখাচ্ছি লাস্টে বলে সবগুলো বলে দেবো পার্ট 2 কোন জায়গাটা দেখেছিল ক্লাস 4
সেকেন্ড রিপোর্ট
ক্লাস 4 রিপোর্ট থেকে না রিট থেকে
সেকেন্ড
পার্ট 2টা কোনটা থেকে সিঙ্গল কোন এরিয়া রিপোর্ট হ্যাঁ কোথা থেকে রিট রিপোর্ট রিপোর্টটা কোন রিপোর্ট My lord, I'm sorry, not from the writ petition. He has learned from page 12 of the first report. First report, but sorry, well, first report, my lord. Page 22. দেখাচ্ছি বল না এটা কোনটা
Page,
my lord, page 12. It starts from page 11. Page 12, clause Roman 4.
yes,
My lord, this has been placed before your lordship. The applicant should possess suitable go down as per the issued by the director so and so, as amended so and so, that within the vacancy location for storage of public distribution commodities running so and so. 401, your lordship note my lord, the place nomination that must be voted. After relying on this, my learned friend's submission was that I have requisite go down and shop room. And my shop room is more spacious than my so far the petition is then the petition is concerned. I have shown to your lordship from page 15 of the first report. If your lordship kindly turn up. This is my report. Total area of my go down 1124. Total area 1124 6.63.
yes,
And your lordship kindly turn to page 18. Right? That is my learned friend. Kindly turn to page 18,
850.69.
my lord. What is the logic for CS shop pump go down? So that more material can be stored. The only purpose. Admittedly, I have the go down which can accommodate more ration articles. What is the requirement? Because what is the ration cards that is within 400 square feet. But your lordship kindly consider in case of a termination or suspension of a dealer of the nearby area, what is the existing practice? The entire card shall be tagged with the nearby dealer.
Yes,
Definitely for temporary purpose. But your lordship knows that this temporary may continue on to 5, 6, 7 years. In that case, those ration cards holders shall leave their ration articles from this shop. So accommodate additional ration articles. More spacious go down is always being preferred. 400 and 200 is enough
yes,
for a dealer to distribute ration articles to his tag card holders. But the situation if arise that other dealers' ration card will be tagged, in that case, for the purpose of emergency, which may continue for years together, a spacious go down is always to be preferred. And in that case also, I am in a better position. For that, if you have to kindly see page 15, last line, last but one line, storage capacity.
yes,
That's the most vital important thing. Page 15, your lordship is see storage capacity 1310. And so far my learned friend is client is concerned. Kindly turn to page 18, storage capacity 991. The prime consideration for appointment of MR dealer is two things: condition of godown, space of the godown, location of the godown, and the second one is financial solvency. These are the only consideration. There is no shade. I have already submitted. Factual aspect I am not going now. Roof, tin shed, concrete. My learned friend has submitted. My lord, there is no bar that the tin shed will not be allowed. Admittedly, he is concrete. I am tin shed. Bank plans both have 50,000 working capital. Now, your lordship, kindly once again kindly take up the first report, page 17. This is the application of my learned friend. I don't know how there is an inquiry so far my learned friend's client is concerned. Kindly come to page 17, serial number 6. Date of the application, 20th January 2023. Condition: on the date of submission of application, there are rupees 50,000 in the bank account. Kindly come to serial number 20. Bank account dated 13 January. On 28, there was not 50,000. There should not be any inquiry. It should be rejected on the threshold. In the application statement, have you rupees 50,000? Yes. I have shown to your lordship on last occasion also. There is a clause also. If any misrepresentation, false submission, concealing of fact, threshold rejection, and shall take steps in accordance with law. I fail to understand a person submitted his application having no bank balance on the date of application. Inquiry has been conducted. I জানে clause number 1650,000. But I have also submitted before lordship that the property, two properties have been disclosed so far the shop-come godown is concerned. One of the property is joint property. It has been deed is with me, but I think that was the duty of my learned friend's client to annex the same. On 17 January 2014, it has been gifted to his, the father gifted is one daughter-in-law and 3 sons. Out of the 1 son applied, disclosing that particular joint property. But there is no NOC from other joint owners. That deed is with me. Since I have not annexed at the time of hearing, I should not. But there was no disclosure in their affidavit that these are the property and this is the NOC from the other joint owner. But part 3, clause 5 also says of the vacancy notice, he has submitted that I am unemployed. But income tax and everything says he is a businessman. My learned friend submitted there is no border. I do admit a businessman can apply for fair price shop or MR distributorship. My case is that concealing of fact, misrepresentation of the fact. You are saying I am unemployed and annexing a document, income tax return. This is contradictory. This is false statement. For that shown down, your application should have been rejected at the threshold. We have annexed all the documents which will appear from page 31 onwards. To the exception to the first report, we have annexed all those documents. They have also not denied, but their submission is that a businessman earning some money from other business is entitled to make application. I also admit the same. But my case is that if there is a misrepresentation, concealing of fact, your application should be rejected at the threshold. You have stated in your application, I am unemployed. You have stated in your application, property holds by me. These are all misrepresentation, suppression of facts. That's how to. My learned friend also submitted before your lordship on question fallen from your lordship that other ineligible candidates why not be inquired into. His answer was, since my client got higher marks amongst all, a doubt arisen amongst the members. Admitted position, members have not taken the decision, only ADM has taken the decision. Since he has got the higher marks. But I can show that another candidate got more marks than me. But no inquiry has been conducted. Because marks is not the issue. Issue is eligible or not eligible. An example I am giving to your lordship. 4 papers. I got 100 in 3 papers. And in 1 paper I got 25. Qualifying marks is 30. Result says you have to pass in all papers. Another candidate got 30 in all papers. Total 120. I got 315. Can I be declared as qualified candidate? Can I be allowed to higher education? No. The law says eligible or not eligible. If not non-eligible, no consideration, further consideration. Chapter closed. Well, one submission has made on behalf of both the parties, that in my writ petition, whatever facts I have stated, whatever prayer I have made, whatever grounds I have taken, I have enlarged my case after getting the reports. The actual replies. After getting the reports. My entire writ petition, what is the submission? 1-line submission. I am a better candidate. Instead of me, you are going to appoint an inferior candidate. What is the ground? Arbitrariness. I shall show to your lordship. What is the prayer? Cancel his offer letter, issue license in my favor. What I have enlarged my case? Again, I am repeating. I am a better candidate. You are going to issue appointment letter in favor of an inferior candidate. What is my ground? You have chosen to select him by adopting pick and choose method arbitrarily. What is my prayer? Cancel his offer, grant me license. What case I have enlarged? I have relied on the documents. Where from he got these documents? In terms of the court's order. It is not my prayer before the court directed them to file a report. Court directed. You played with the court. First direction, file a report in the form of affidavit annexing all reports. No, only one report. Second direction, file that report. Then report comes. Third one, the state advocate submitted it with the court. Please allow me to submit a report. These reports I have scanned. I have argued on the basis of that reports. This is not my case. You have concealed, you have sought to conceal before the court also. Despite direction, you have not submitted all the reports at the juncture. Time and again, court has to interfere. It is a court's query to adjudicate the issue in a proper manner. Direction has been given upon the state to submit the report. And I have used that report by way of filing my exception in terms of the court's order.
Yes.
There is no further submission so far my writ is concerned. Prayer is very specific, ground is very specific, pleading is very specific. Within the periphery of my writ petition, your lordship can always allow my writ petition holding that my client is a better candidate, he is not eligible candidate, his candidature should not have been considered. Accordingly, I want to quash this offer letter and grant license to the petitioner number 1 within the periphery of my writ petition. That is the order dated 14th May 2024. I am just reading. Heard Mr. Sohedin Huda, learned advocate. Mr. Suman Sengupta, learned advocate for the state respondent, also places his points of argument. During course of hearing, his order dated 14th of May 2024.
14th of May.
14th of May.
Yes.
Well, kindly see second paragraph. Last 3 lines. During course of hearing, the seeks to file supplementary affidavit in order to produce the order of re-inquiry of the additional district magistrate. This is a state's fair. We want to file a report for proper adjudication. Not even the direction of the court. Can I be barred to make argument on this report after getting leave from the court to file an exception? No new case has been made out because my writ is covered all points. My learned friend also relied on 3 judgments. The first judgment reported 2009 volume 8 Supreme Court cases, page 310. Paragraph 15 has been relied on.
জাজমেন্ট গুলো আলাদা করে ফাইলে রাখেন, সব এখানে রেখে দিয়েছি। Yes.
But this is a case where a dismissal employee came before the Honorable Court for quashing of his dismissal order. The judgment which has been placed before Lordship, paragraph 15, Lordship kindly state will come to paragraph 15. At page 316. The legal position is well settled that the power of judicial review is not directed against the decision, but is confined to the decision-making process. The court does not sit in judgment on merits of the decision. It is not open to the High Court to reappreciate and reapprise the evidence of the laid before evidence laid before the inquiry officer and examine the findings accordingly recorded in the inquiry officer as a court of appeal and reach its own conclusion. In the instant case, the High Court fell into grave error in scanning the evidence as it was a court of appeal. The approach of the High Court in consideration of the matter suffers from manifest error, and in our thoughtful consideration, the matter requires fresh consideration by the High Court in accordance with law. On this short ground, we found to so and so. But this is a settled principle. Court can go only decision-making process, not the decision.
Yes.
After finding that decision-making process is not good, court can pass an order cancelling the decision. Now, Your Lordship, kindly just go through the paragraph 14 of that judgment. Very judgment. The previous page. What court can do? My learned friend has shown to Your Lordship that what court cannot do. Just I am showing from this judgment. Kindly take up paragraph 14, need not go through the same. Kindly turn to next page, paragraph 315. After 4 lines from left-hand side, sentence starts, the High Court may. Have Your Lordship got? Page 315, first paragraph from left-hand side, after 4-6 lines, the High Court may, right-hand side.
Second paragraph.
No, first paragraph. After 1, 2, 3, 4, 5, 6 lines, the
Yes.
evidence, then the High
Yes.
Court.
Got it.
Now I'll show to Your Lordship what court has the power. The High Court may interfere where the departmental authorities have held the proceedings against the delinquent in a manner inconsistent with the rules of natural justice. First, or in violation of the statutory rules prescribing the mode of inquiry, or where the authorities have disabled themselves from reaching a fair decision by some consideration extraneous to the evidence and the merits of the case, or by allowing themselves to the influence by a relevant consideration, or where the conclusion on the very face of it is so wholly arbitrary and capricious that no reasonable person could ever been arrived at that decision. The departmental authorities are, in the inquiry, is otherwise properly held the sole judges of the facts, in case there is some legal evidence or what their findings can be based on an adequate or reliability. That evidence was not a matter which can be permitted to the canvass before the so and so. What is our case? What is our case? Beyond the scope of statute. One of the member of the committee decided to send his own man, to select his own man.
Reason for showing this judgment, I think Learned Junior has not taken the note properly. My reason for showing his judgment was, in the writ petition, the challenge is of the decision, but not the decision-making process.
Yes.
Whole petition is silent about.
Paragraph 16.
That is my reason for showing this judgment. Decision-making process is not under, it is beyond the scope of the writ petition.
That I shall show to your lordship. So, my lord, decision-making process, my learned friends is admitting, can be challenged. And I have shown to your lordship that decision which has been taken contrary to law by adopting pick and choose method, by encouraging nepotism and favoritism. Now, your lordship, kindly take up the writ petition, since my learned friend is saying that I have not challenged. First, your lordship, kindly take up paragraph 14 of my writ petition. Paragraph 13, last 3 lines. I'm reading from paragraph page 7, your lordship, kindly come. Last 3 lines from page 7, last 4 lines. Sentence starts from right hand side. It is also pertinent to note that the Food and Supplies Inspector Korondiki block has rejected the application of the respondent number 6 after his inquiry. The respondent number 6 is otherwise ineligible to award the fair price of dealership, and the issuance of the said purported offer in favor of the respondent number 6 was and is violative of the said vacancy notices oil the provisions of West Bengal control order. This is my pleading. Then paragraph 14, last 4 lines. The petitioner apprehends that the approval of the respondent number 6 application in contravention of law and justice is the result of extraneous consideration. That's the language of the Supreme Court decision. Corruption, underhand dealings by and between the respondent number 4 and the respondent number 6. What more? Next paragraph. Paragraph 16. The respondent authorities have failed and are neglected to consider or respond to any of the representation given by the petitioner. No hearing was ever granted to the petitioner in respect of the said fair price dealership selection process, nor were any of the contentions of the petitioner were taken into account of the so and so. What is my representation? Just one paragraph I shall show to your lordship. 56, your lordship, kindly see. One paragraph. It starts from page 55, last paragraph, page 56. Last 2 lines. You are further requested to cause a fresh inquiry and provide the offer letter followed by a valid license to the most eligible candidate. Not to me. The most eligible candidate should be granted license, not an outsider. He is not an eligible candidate, which in this case is myself. I am not paid for to grant me license. My case is that the most eligible candidate should be provided the license. What is my prayer? You will also kindly turn up. At page 15. First, pair B, to grant me dealership license. Pair C, cancelling the offer letter. Pair D, very important. Writ are on the nature of direction and not the nature of certiorari. Be issued directing the respondent authorities to transmit the said offer letter dated so and so, September so and so, and the records pertaining thereto to this honorable court, such that the same may be quashed. Entire thing. What more I shall pray for? Writ of certiorari being the records quash the same. Pleading arbitrariness. Grounds nepotism. Prayer give me license, cancel his, and being all the records quash the same. Is it not decision-making process?
Ground number 6.
And ground number 6, once your lordship kindly see at page 10. At page 10, for that the said purported offer letter dated 22nd of September 2023 has been issued illegally, arbitrarily, unjustly, unreasonably, and in a manner violative of the principle of natural justice, equity, and good conscience. What more? Next judgment কি লিখেছে? Next judgment কি লিখেছে গালি? গালিটা। Sir গালি বলি, sir গালি। 2017 Supreme Court cases online paragraph 1. This is a division bench judgment of the same principle. I am not making my submission. 2017 decision making process, not the decision.
Yes.
The next judgment, third one, দেখেছি আমি নিয়ে পড়েছি। 2009 volume 14 Supreme Court cases, page 132. Well, this is some number of paragraph has been relied on. 2009 volume 14 Supreme Court cases, page 132. Well, this is a case where copywriters came before this honorable court saying that we have a copywriter license for copywriter license. We should be given employment to the government departments.
Yes.
And we shall be given the same salary for the persons who are permanently discharging the duties. The division bench of our High Court, this goes from our High Court, says admitted their claim. Matter went up to the Supreme Court. Supreme Court says, what is going on? You are not the government employee. A license has been granted to you to discharge the duties of copywriter. Where is your appointment letter? Where is your selection process? You are not entitled to get the service. You are not entitled to get the entire benefit which is being provided to the employees. You are not eligible. Possibly, my lord, this judgment I can rely before your lordship. You are not entitled because you are not eligible. This is my case. Coming and saying that I shall be given license. You don't have any bank balance. You don't have any go down as per prescription. Sir, please grant me license. Go down, inspected, found not suitable. Inquiry report says you don't have any money on the date of application. Person has been selected. This is not a case of arbitrariness. This is not a case of nepotism. This is not a case of favoritism. Then what is the definition? Entire definition will be changed. But it has also submitted on behalf of private respondent, my friend, that hot and cold. In one paragraph, I have stated, I have shown to your lordship, there should be a second inquiry. According to them,
Paratin. Lordship has referred to that. I answered.
Paratin, we have stated there should be a second inquiry. According to them, since I have paid for an inquiry, inquiry is permissible. Second inquiry is permissible. But not in your case. Since you have paid for inquiry, we are inquiring private respondent. What a logic! A person seeking inquiry, relying on that statement, inquiry is being conducted in respect of other who has never paid for. Yesterday, when my learned junior told me that this is the logic, Mr. Somon Sengupta argued before the court, it is permissible because petitioner himself has sought for an inquiry. Accordingly, we have inquired the go down of the other person.
No, my argument was not that.
This is I must not say it is ridiculous. No,
Yes.
up to that I have said Mr. Gali. Now I am saying Mr. Sen.
If you say it is deholds the rule re-inquiry, then why did you pray for it? It is appropriate and improper.
Yes. And accordingly,
It reply to Mr. Sengupta.
Mr. Sengupta court says, accordingly we have conducted inquiry in respect of other person. What a logic. I want a judgment for this, my lord. I want a judgment against me, or at least for this point. It can be personal, permissible. Even law does not permit. If out of 10 candidates, 1 candidate pay for the inquiry, it can be done to other person, not to others. You will also kindly record it. This is a submission of Mr. Sengupta. Then, my lord, Mr. Sengupta
Yes.
It has also been fallen from your lordship, so far Mr. Sengupta is concerned.
সেনগুপ্ত ওই জাজমেন্টে অ্যাকচুয়াল আর্গুমেন্টটা ছিল না কি আর্গুমেন্ট ছিল বলো
আমি যেটা শুনেছি বুঝেছি।
My lord, regarding Sengupta is concerned, Sengupta is saying that, my lord, this point, my lord, unless Siriat is not misunderstood this point.
বলো না
But Mr. Sengupta is said that
I have heard what he said.
That's it.
You don't have to again react. Yes.
My lord, re-inspection, he has submitted, it is permissible. Then logic I have already submitted,
সাহেব বলেন বাইরে ইন্সপেকশন ইজ only one candidate এটা জজ সাহেবের কোশ্চেন ছিল
and it has fallen from your lordship possibly, my lord. Then why the inquiry in respect of only one candidate when there are so many ineligible candidates? Possibly no proper answer has been given.
জাজমেন্টে
And he has relied on, my lord, clause 24
Yes.
part to re-inquiry. Just your lordship kindly see clause 24. 20 subclause 4. In regard to second inquiry. At page, my lord, 1.20. Roman 4. May I read, my lord? Notwithstanding anything contained in the subclause 3, if the state government deems it necessary in the exigence of public interest, once again, in the exigence of public interest, to expedite the process of, kindly consider, to expedite the process of engagement of dealer, it may by an order take up under the control the engagement of the dealer at any stage of proceedings of application, and if necessary cause the inquiry referred to in subclause 3 by the inquiry committee comprising of an office or group of officers of the Food and Supplies Department, duly authorized in this behalf, and the concerned subdivision of Food and Supplies, and on receipt of reports also. Three things: exigency for engagement of dealer in early stage, inquiry by the inquiring team as per clause 3 of food officials. Kindly turn to clause 3, previous page. Subject to the date sheet mentioned in the subclause 1, the application for filing of the vacancies as notified so and report shall be invited from so raising the registered corporation on receipt of the application forms and accordingly documents so subdivisional control of Food and Supply shall process the case and get the case inquired into by a competent officer or group of officers and send a report in formal to the comment from so to concerned district controller Food and Supply. The said district controller Food and Supply shall place the matter before the district fair price sub selection committee. Does clause any of the clause says additional district magistrate? Any of the clause says suggest food official?
OC food.
OC food. Why clause 4? His case is that clause 4 for him second inquiry, not by the food officials, by the state government, not by the directorate. Kindly read 1 second, your lordship. The state means ministry. Only secretariat level can do it for exigency, but not beyond the scope of 3, subclause 3. Even state cannot do it by another person. Only power which has been vested under subclause 3 of the control order. That is subdivision controller or any person to be deputed by him in any manner, office of the district magistrate, any employee, even not ADM, not by the DM, can take a decision for inquiry and conduct inquiry.
expedite করার জন্য re-inquiry না
Re-inquiry কেউই পারে না।
hopefully for re-inquiry
One principle has been placed before lordship, fishing out evidence, Mr. Shenmukta. The fishing out evidence from the civil procedure court is if the plaintiff forces a defendant or the defendant forces the plaintiff to produce some evidence rather compel him and subsequently take advantage of that document. That's the principle of forcing out this evidence, fishing out evidence. I fail to understand why this submission has been advanced on behalf of the state. In our case, we never paid for any document. Court on satisfaction prima facie found that a case has been made out, injunction has been granted, directed the state to file a report annexing all reports. Second order also by the court. Third order on pair of the state report has been submitted. Am I not entitled to delete those reports when court has granted me leave to file an exception? Is it say I have forced the state to place a document so that I can take advantage of those documents? The principle of fishing out evidence is absolutely a new command. I don't know why this principle has been placed before your lordship. The judgment relied upon, judicial review has also been placed before your lordship, and 2009 volume 9 Supreme Court cases page 1. Right?
The not maintainable letter. Child.
He has also submitted before your lordship that since I have not prayed for to grant me offer letter, only prayer has been made for license, the prayer is defective. In his submission is accepted, then he possibly knows the procedure. First offer letter, I have to pray for. Then I have second prayer would be, please allow me to deposit the license fee. The third prayer would be, issue me appointment letter. Fourth prayer would be, grant me license.
Provisional license.
Fifth prayer would be, tag the ration cards. Seventh prayer would be, allot me ration articles. Ninth prayer would be, allow me to distribute to the consumers. If the logic of Mr. Sengupta is taken, I have to take at least 10 prayer only to reach my license. According to my understanding, this is an absurd proposition. Now, your lordship, the judgment which has been relied on, please the 2009,
11,
column 9, Supreme Court, page 1.
page
It is the principle.
134.
Paragraph
134.
131. Just a minute. Page টা কত?
Page 1.
Page 1 থেকে শুরু হলো। Just a minute. Public person. তোর আনলিস নি বইটা? ওটা 2009 টা আসেনি, মেলেনি পেজে। Public ওটা কি পয়েন্টসটা কিছু পাবলিক
ওই domain.
ও ডোমেন। যশোর ছেড়ে দাও। At 2020, just a minute. Extremely sorry, my lord, this book have not brought. Yes. The matter relates to a property case. I fail to understand, my lord, I have gone through it. I fail to understand what logic he sought to be placed before your lordship from this judgment. Paragraph 134 I have gone entirely gone. United Kingdom, which is some foreign countries reference has been given, but no ratio has been at least decided in paragraph 134. Public right.
Distance from.
Now, my lord, the last judgment which has been placed before your lordship, 2024, SCC online, Calcutta 4278, para 1. Same principle of judicial review, which I have already answered. So, what is the scope of the writ court and what is my case? And lastly, I shall not linger my submission. The last submission I have already placed on that day, I could not hand over the judgment. This is reported in 2012, volume 2, Supreme Court cases, page 1, paragraph 107 at page 83. The Joseph page 83. Only one paragraph, my lord. আমার বইটা দাও। জাজমেন্ট আগের দিন বলেছি, কপিটা জসের দিতে পারে। দেখি
Natural resources.
ওইটাই Paragraph 107. And actually, I have handed over that copy, but it's not missing. Just I'm reading and I'm concluding my submission. Paragraph 107. Natural resource. Whether this judgment is squarely cover our case or not. 2012, volume 10, Supreme Court cases, page 1. Natural resources, para 107 at page 83. Just I'm reading, my lord. Your lordship at page 107. Para 107.
Paragraph 107. Yes, you have read the,
My lord,
have
then I'm not. That I'm not. That
you have read it. Paragraph.
So, my lord, entire paragraph 107 shall to maintain principle of natural justice, there should not be any biasness, unreasonableness, unfairness in a selection process. There should not be any nepotism. There should not be any favoritism in any case so far selection of government largesse is concerned. These are my respectful submission before lordship. That being a better candidate, I must be granted the license, the cancelling the license already provided to the private license. And there is a stay order possibly, my lord. In fact, he has not at least got the license till today. So on cancellation of his offer letter, being the most suitable candidate, I should be accommodated. Yes? Allotment one. License.
Allotment was also made,
That was withdrawn by.
but I had to return the items.
My lord, in terms of the court order. Whatever may be, my lord, this is the position. He has generated license, but this court did not allow him to continue the business, rather to start the business.
এটা authority করেছে, authority করেছে।
He has to return the goods.
Eligible but not full. Actually, full বলেছেন।
The order Roman remains.
These are my sir.
After reply to given Uda Tuni note for Article 226 clause 3.
First argument should go to here the was
Okay, please take down. Argument on behalf of the parties concluded. Made CAB. এগুলো রাখো।
I'm get clear, much of it, about patience sharing. All of us are. I'm get.
Yes.
The matter I am for the petition. To subsequent fact, I have.
Which
believe
appeal
I-
for the state.
I am filing the supplementary affidavit, and today is stay application as the selection process as per the notification of 2022 4/11/2022 initiated, and several candidates were participated, and the last of all interview was taken among the two candidates, petitioner and the private respondent.
Yes.
Petitioner and private respondent. Interview letter is page P7 44. Forty 44. Interview was taken on 25th February 2022 at 11:30. Here, the petitioner first Serial number 1 is the petitioner and serial number 2 is the private respondent. Interview was taken in a particular room where all members of the selection committee were present. And in the same room, both the candidates, petitioner and the private respondent, were present. Yes, Mr. Chopra. It is related.
Well, notice has been earlier, well,
Yes, selection process interview.
page 44, my lord. How much later?
Letter of interview.
Yeah, my lord. And number 1, Milani Kumar Bishas, Milani Kondar Bishai. Second part was not selected. Next letter. Next petition. Right.
Yes.
Well, thereafter, my lord, another notification during the pendency of the writ petition has been filed, has been issued by.
Earlier notification cancelled.
And earlier notification was, it's another notification cancelling other.
Yes. All previous notification cancelled hereby. This is a single order. So what is your prayer in the writ petition?
Because there was a selection process. 2 candidates were asked for. Another probably failed to fulfill the criteria. Therefore, in order to accommodate the favored person, this notification, even during the pendency of the writ petition, is being issued. First order. My first order, kindly 6, page 6. Report in the form of affidavit. In the form of affidavit, it is given. Supplementary affidavit. Supplementary affidavit, my lord, kindly see page 10, page 6. Stay application process. In stay application also it is there. Order is there. Page 6. Page 6. Page 6. Page 6. I've got the order 9th April 2024.
Yes.
Nothing, my lords. No report, no affidavit has been filed.
Yes, what is the report? Any report is ready?
Yes, my lord. Report, my lord, we have received. But my lord, may I just, my lord, 3 respectful submissions in this matter. One is, my lord, yes, there was a direction, my lord, by the honorable court to file a report. From the report, I find, my lord, that my first respectful submission is, kindly, my lord, may I respectfully invite your lordship to the prayer of the writ petition. What does she want? The petitioner wants a mandamus, prays for a mandamus. What? To void the engagement letter of the dealership of concerned area would not be given to the petitioner. As per the interview taken on 24th February 2023, where petitioner was qualified and respondent number 5 was disqualified, which was openly stated by the respondent in presence of other members of selection. So this is the prayer for mandamus. Now, may I respectfully invite your lordship to minute paragraph 9 of the writ petition. At page 5. After receiving the interview letter, your petitioner and the respondent number 5 duly appeared before the said respondent at the correct time and place, and both of them in a particular room of interview asked by the subdivisional controller, and as a relevant paper was satisfactory as regards the petitioners, therefore no major question asked to her, but the said officer asked the respondent 5 that your godown is small than the required area and your security deposit is less than the required amount of 50,000. So it was expected that the engagement of FS would be granted in advance. So on expectation, he said, I have been qualified and that gentleman has been disqualified. Now, my lord, on one more paragraph, paragraph 12. So after 9 comes paragraph 12. What does she say, the petitioner? Your petitioner states that after verification of the application of all 2 candidates were treated qualified, and at the time of interview, the respondent was treated disqualified. Wherefrom does she get? As regards godown and security deposit, yet without issuing an engagement letter to the petitioner, who is the member of SC community, the concerned respondent is sitting tight about the matter. Therefore, unless direction is given to the concerned respondent to issue the engagement letter to the petitioner, as she was only qualified candidate, as per the interview dated so and so, your petition will be deprived of justice and will suffer to that. So in 9, she says, paragraph 9, that since the private respondent was asked some question, I was asked some question, it is expected that I am selected. And para 12, she says that, yes, give me the engagement letter since I am an SC candidate. And in mandamus, she says, she has come to the conclusion that, yes, he was disqualified, the private respondent, I was qualified. So now, paragraph 9 and expectation crystallizes to, I have been engaged. For that, mandamus is prayed for. So, my lord, kindly sees the paragraph 9 in the affidavit. She says 1 to 11 to my knowledge. So, my lord, why the mandamus can lie on, writ petition itself can lie on apprehension, assumption, presumption, that is the good thing to be gone into. Yes. Allow me to reply. Allow me. Yes. This is my first respectful submission. Now, my lord, the report, my lord, says, may I respectfully hand over a copy of the report?
Report has been
No.
Report was directed to file with affidavit, I think.
On affidavit, since the affidavit has not been shown, but I have received the, my lord, okay, before swearing, if I can place, but just the fact is this, it will not change.
No, then you shown the affidavit. Come on tomorrow then.
Well, one thing.
And thirdly, my lord,
They may have the produce the report.
One thing, just have replied to him. First of all,
No, let him assess what you would do.
let's complete.
since my lord, there was a direction to file the report on affidavit, so my lord, we should comply with this. But fact remains as on date, nothing remains. My third respectful submission, which I said, I have threefold submission. A new notification has been given, has been issued. The very first line of the new notification says in cancellation of the earlier notification. So, my lord, a new cause of action has arisen.
Yes.
The entire scope of the writ petition was revolving around the earlier notification.
So you come with the affidavit.
So on issuance of new notification is a new cause of action.
I
It
understand.
cannot be brought on record by supplementary affidavit. Supplementary affidavit can supplement the cause of action, but cannot supplant the cause of action.
Yes.
He should come up with a proper writ petition challenging the new vacancy notice along with the grounds of challenge thereof. So how can it come in the form of supplementary affidavit, Lordship? This is my primary challenge to the filing of supplementary affidavit, and the stay application also prayed for in connection there too. It's a new cause of action. So supplementary affidavit we file is to supplement the cause of action, but not supplant the cause of action. It's a new cause of action altogether on issuance of a new notification. So this writ petition, which is pending with your Lordship, is infructuous. Yes, of course, on filing of a report on affidavit, it will come to the conclusion. But so far as the new issuance of new vacancy notice is concerned, how can it come as in the form of supplementary affidavit? There should be a complete proceeding in the form of writ petition with grounds of challenge.
There
It is a,
you file that affidavit by tomorrow.
Madam, just one.
kindly give, may I get 7 days below?
7 days.
My lord,
By next Wednesday? By next Wednesday?
Madam, one thing, Mr.
In the maintenance service.
Well, in the just to reply to two question. My learned friend is saying that in a writ petition, mandamus is asked for. Yes, one can ask for mandamus. It is the discretion of the court. Court can direct or court can not direct. One thing. First thing is that there was this administrative order. There was a direction by this honorable court to file a report and the form of affidavit that has been completely avoided. Second point is that you are talking about new cause of action. This is a continuation of the order because there was no reason stated in the notification that what prompted the administration to cancel the earlier order. Because this is court, the honorable court is in the sessions of the matter, earlier notification that has not been concluded. Therefore, one can file another writ petition because the new cause of action, there is a settled proposition of law. One has to challenge that one or other. But what would be the earlier orders? There was a notification. And when the court, honorable court is in the sessions of the matter, it was regulated that this is a malafide. And honorable apex court said that if the court acted in a post-haste manner, presumption is malafide, arbitrary. I will rely judgment of the Supreme Court. Presumption is arbitrary and malafide. When the honorable court in the sessions of the matter, there it is the notification comes out. So this can be brought to the notice of the honorable court that this notification has been filed without adjudication of the earlier one. Then one can file a new, just to defeat the writ petition, one can file a notification and say, go and file a writ petition, challenging that one. Then there will be an unending process of. Well, now they are trying, we'll go to that one, they will reply that one. Till disposal of the 7 days stay cannot be done. The sky will fall because it is their fault. They have not filed any report on affidavit as per direction. So that 7 days stay will not. In any way, no, it will not prejudice them.
New notification is not the subject matter of challenge.
No, maybe, but the earlier notification is subject matter of the challenge.
So earlier notification is under challenge.
No, earlier notification has been challenged. It is not simply the earlier notification has been challenged in order to defeat the writ petition, which is not permissible.
Okay. Please take down. Jan 1 of 2024. This is an application for stay of new notification dated 13/5/2024.
The supplementary affidavit will not application. It's a supplementary.
No, can one is there.
Can is for stay of that.
Yes, can is for.
No, they are bringing on record the new notification. When you are supply affidavit,
I understand.
then comes stay.
I understand. This is an application for stay of new notification dated 13/5/2024. বলেছি তো? Till the disposal of the read petition, the instant read petition number WPA 8500 of 2024. Full stop. The learned advocate for the petitioner also submitted a supplementary affidavit in support of his read petition. Full stop. Learned counsel for the petitioner submits that the read petitioner challenged the vacancy notification dated 4/11/2022 and also challenge the conduct of the respondent authority for not appointing the present petitioner in the said new FPS shop as a dealer. It is the further submission of the petitioner that the state authority was directed to file the affidavit in opposition.
Not opposition. Report on affidavit.
Report
In the form of affidavit.
in the form of affidavit.
Lordship.
কি বললাম? It is the further submission of the learned counsel for the petitioner that the state authority was directed by this court to submit a report in the form of affidavit, but the state authority till today has not filed any such affidavit. Full stop. He submits that surprisingly the state authority has again issued a further notification on the impugned site on 13/5/2024. It is the prayer of the petitioner that till the disposal of the instant read petition, the state authority may be directed to not to proceed with the notification dated 13/5/2024 in respect of the impugned site. Full stop. Learned counsel, Mr. Ghalib, appearing on behalf of the state authority, submits that the entire read petition cannot be entertained. Full stop. The prayer of the read petition disclose that the present petitioner wanted to be engaged as a MR dealer on the basis of apprehension, on the basis of mere apprehension. It is the Mr. Ghalib further argued that it is the case of the petitioner that during interview, the petitioner and private respondent number 5 was called for, and during the course of interview, the member of the interview team stated to respondent number 5 regarding some disqualifications, regarding some of his disqualifications. On hearing the conversation of the member of the interview team with the private respondent number 5, it is the assumption of the petitioner.
Expectation. This is
It is
a what
assumption and expectation of the petitioner that he, being the successful candidate, required to be engaged in the said vacancy notification. Full stop. Mr. Ghalib further submits that the mandamus cannot be issued by a court of by a read court, which is on the basis of mere expectation. He further submits that the next paragraph. He further submits that Mr. Ghalib further submits that the instant application was filed. Instant application being Can 1 of 2024 is filed to stay the new notification dated 13/5/2024.
preceded by supplementary affidavit. First supplementary affidavit,
Okay.
then application.
Preceded by supplementary affidavit.
There is no ground, Miller, because Lordship knows my read rule says.
I understand.
that
I
will be
understand.
grounds.
I understand.
But there is
challenge.
also doctrine of legitimate expectation is there also.
Okay.
Read petition should, it's a read
Just
rule.
wait. কি বললাম বল? New notification dated 13/5/2024. Supplementary affidavit. Mr. Gali further submits that the supplementary affidavit may have attached the new notification, but the new notification actually not under the challenge before this court in the instant writ petition. Thus, it is a new cause of action. The petitioner may prepare a separate writ petition to challenge the notification dated 13/5/2024
If so desire.
if so desire, but but she is not entitled to get any relief in respect of new notification dated 13/5/2024 in this writ petition. Full stop. Refuting the contention of Mr. Gali, Mr. Chakraborty submits that the instant writ petition is in respect of the notification dated 4/11/2022 in respect of the impugned site. It appears that during the pendency of the instant writ petition, suddenly the state authority has issued a separate notification in respect of the same site by cancelling all earlier notifications. Full stop. The act of the state authority, is not at all legible, is not at all permissible in the eye of law when the court is in the session of this matter. Mr. Chakraborty further submits that as the notification was issued in respect of the impugned site which is under challenge before this court, the read court in the instant writ petition can very well issue an appropriate order in respect of the new notification dated 13/5/2020. For the learned advocate, learned counsel appearing for the state further submits that the report of the state is already ready. The report shall be filed within a week with a form of in a form of affidavit as directed by this court. For the learned counsel, peruse the supplementary affidavit along with the CAN application being CAN 1 of 2024. Supplementary affidavit contain the affidavit of petitioner with a fact that a new notification has been issued by the state of West Bengal in respect of the same site. CAN 1 of 2024 is an application for stay of the new notification dated 13/5/2024. It is true that in present writ petition, the mandamus was asked for against the state respondent so that the present petitioner may be engaged in the FPS shop in respect of the vacancy notification dated 4/11/2022. Admittedly, the present petitioner has not applied for the license in respect of the new notification dated 13/5/2024. Thus, the new notification dated 13/5/2024 is completely out of the ambit of the determination of this court in WPA number 8500 of 2024. Considering the same, I am of the view that the present application for stay, praying for necessary order in respect of new notification dated 13/5/2024 appears to me not tenable in the eye of law. The present petitioner has new cause of action. He may apply before this court if she desires in respect of the new notification dated 13/5/2024. However, According to however, state is given liberty to file the supplementary affidavit, file the report in the form of affidavit within 28th August 2024. Let the matter appear in the list under the heading of to be mentioned on 28th of August 2020.
There was a liberty for filing exception also to the petition. So if they want, they can file
Yes.
exception.
The petitioner is at liberty to file the exception against the
Prior
report,
to that date.
against the report in the form of affidavit
In the
filed by the state.
একটা copy দিয়ে দিও exception.
Next,
My lord, I am for the petitioner plaintiff, my lord. Plaintiff petition.
Nipen, can want a display for can want a display. Yes,
My lord, in fact, the revisional application has been filed, my lord. My lord, since my innocuous pair of the plaintiff was turned down by the court below. But I am the plaintiff filed suit for partition. My lord, in the my lord, partition suit, my lord, defendant initially did not file written statement when the suit was fixed for peremptory for ex parte hearing. At that juncture, the defendant appeared and defendant filed written statement along with the counterclaim. No dates were fixed for filing written statement with regard to the counterclaim by the plaintiff, because your lordship knows that written counterclaim is also treated as a suit, and unless the plaintiff files written statement, that will be hard ex parte. And thereafter, my lord, ultimately
now
the
what happened? It's a partition suit.
partition suit. In the
Sir.
partition suit, I paid for partition. Defendant appeared
Did not appear.
letter
Initially
stage.
did not appear.
Initially did not appear. Letter stage.
Run ex parte,
It was not it was fixed for ex parte.
fixed for ex
At
parte.
that juncture, defendant appeared,
Appeared,
filed
filed a
written
written
statement with
statement
counterclaim.
with counterclaim.
But the court did not fix up any date for filing written statement by the plaintiff. Ultimately, it came for the final hearing. Came for final hearing. At that time, the plaintiff noticed that written statement with regard to a counterclaim has not been filed. An application was filed, and the court allowed the same, fixing on 20th of November 2006 as the date for filing written statement. My lord,
Against the counterclaim.
Against the counterclaim. My lord, the more are concerned, my lord, in the diary, it noticed noted that it's for written statement. Not my lord, was not mentioned the written statement by the plaintiff. The lawyer committed mistake, my lord, that he thought that my lord thought that written statement to be filed by the defendant. On that day, written statement not filed. Then just immediately next day, the mistake was noticed, and on that date, an application showing cause was filed that due to such and such reason, under wrong impression, it was not filed. The court, the so-called petition was filed. Court did not, my lord, allow the same. My lord, if my lord, consequence will be, I will be totally non-suited regarding the counterclaim filed by the defendant. This is one aspect. My second, my lord, another application was also filed on that my lord, on the same date it was heard. That was filed, my lord, because defendant in the counterclaim, my lord, prayed for relief, relief against the plaintiff, and the plaintiff, my lord, your lordship knows that as per the amended Code of Civil Procedure, particularly under Order 7, Rule 14, along with the written statement, the list of the documents upon which the party wants to rely, that is to be given. My lord, that has no list has been given. That's why the plaintiff also filed an application under as complying the provision of Order 7, Rule 14. My lord, that directing the defendant to disclose the documents on which the defendant wants to rely his counterclaim. My lord, the court also rejected the same. My lord, thereafter we had come here. It was, my lord, admitted. Stay was also granted, my lord. And thereafter, my lord, the matter ultimately appeared in the list of Honorable Justice Prosenjit বিশ্বাস. His lordship released the matter because he was initially, in the first life, he was practicing in the Nodia Krishnanagar court, and this is a matter pertaining to Krishnanagar court. So, for the personal ground, he has released the matter, and it has come before.
So how CO is pending since 2007?
My lord, it is pending. My lord, nobody took care. My lord, it came. Once it was dismissed for default, it was restored. But other side was given notice. They did not appear. My lord, again, when the matter came in the list of Honorable Justice Prosenjit বিশ্বাস, and another notice was given, appeared, my lord, is thereafter. My lord, now the today is also not there, my lord.
Then you serve a notice, I shall dispose of this matter.
If your lordship so desires, I shall give. But my prayer is my totally innocuous prayer. I want.
I understand the entire case.
Yes.
You serve the notice.
All right.
Please take down.
Well, upon the learned advocate who appeared in this matter, I shall serve.
Upon the learned.
Yes.
This is one of the assigned matter. Heard the learned advocate for the petition. Full stop. It appears that the incident CO is pending since 2007. Full stop. None appears on behalf of the respondent. Full stop. The petitioner is directed to serve a notice upon the learned counsel appearing on behalf of the opposite party, informing the fact that the matter shall appear in the list on 10th of September under the same heading. Yes, this CAV matter.
Lordship.
What happened?
That the claimant has died. Was
Okay.
initially case just after the matter was concluded, the hearing was concluded, died on the 17th, where I have preferred two applications, one in the appeal and another in the cross objection, both praying for substitution of the widow and the daughter, the appeal as well as the cross objection. I have annexed. I have given a copy to Mr. Singh. I have annexed the Aadhaar card, the death certificate, as well as the PAN cards, which shows the relationship between the claimant.
So, one, namely Urbosi Bajaj is the widow.
Yes.
And two is the daughter,
Yes.
Arundhati Bajaj.
So respondent number 1, A and B, we can substitute. And well, they have executed a Wakalatnama, I have annexed the Wakalatnama in the application as well.
Okay, please take down. Yes.
Milord, no issues with regard to the Milord, this substitution. Milord, I was discussing, Milord, these are formal, Milord, no issues, Milord. Only one thing, Milord, if your lordship, Milord, in any event holds that claimant is entitled to, Milord, on the point of non-pecuniary expenses, Milord, this pain and suffering and this future medical expenses, Milord, since this death is not related to the injury, your lordship will kindly take note of that, Milord, because, Milord, I am not today, Milord, I have come with the judgments to trouble your lordship on those, Milord, because matter was CAV. But, Milord, there was one judgment of Kahlon. My learned friend, Milord, agrees to that. Your lordship, Milord, Milord. That takes note, Milord, that if in an injury case, Milord, the injured claimant dies during the pendency of the claim case, Milord, and Milord, with the death is not related to the injury, then, Milord,
Not related to the injury.
death is not related to the injury, Milord. Likewise,
Yes.
Milord, Then, my lord, with regard to the non-pecuniary and my lord, with regard to the future medical expenses, my lord, what to be taken into account, what not to be taken into account. Not if your lordship my lord takes it up my lord any other day, or my lord, if we only just forward that judgment
Forward
to
the
your
judgment
lordship, my lord,
regarding the-
that would take care of my lord, because I have subsequently, my lord, I have not gone through any further judgment, my lord.
That
After
means future
Kahlon,
medical expenses.
future
will
medical,
not
because my lord,
require
now he's there, he's not there, my lord. So my lord, those questions, my lord, would not arise.
what is the view of the Supreme Court?
There have been several judgments of the Honorable Supreme Court. Now, my lord, in 2021, Supreme Court passed one judgment, Oriental versus Carlo. That is the final judgment, binding judgment. Everyone is following that judgment. Now, my lord, that says that since tribunal has passed an award, that estate, that award devolves on the legal representatives. So they are not claiming compensation for the death. They are claiming compensation for Aman Bajaj, the claimant, through being legal representative.
Yes.
They only step into the shoes. So they have a right to defend the award of 135, which is passed in this. Now, with regard to medical expenses, with regard to pain and suffering, with regard to attendant charges, doctor charges, Supreme Court has held all those has to be awarded. Malad, these are the two judgments I am handing over. This is the judgment of Oriental versus Carlo. This is 2022-13 SCC 494. This is the Supreme Court judgment.
Now, what Supreme Court says?
It has to be awarded.
Awarded
Only enhancement on the High Court after the death of the claimant cannot enhance the pain and suffering, all the personal damages, pain and suffering or loss of longevity of life or attendant charges.
Okay.
Yes.
Okay,
But whatever is awarded, they can defend it fully. And my lord, following those judgment, exactly the point which Mr. Singh raised, these are the points which were raised before the Delhi High Court. Delhi High Court has passed a judgment in 2023 November, 21st November. It has listed all the judgments passed by the Supreme Court. It has held what the Supreme Court has held, and it has passed a judgment enhancing the compensation. I am handing both of those judgments.
My lord, I have not, my lord, gone into this aspect, my lord, because just now, my lord, before this matter was being moved, I was discussing with my learned friend. Because, my lord, Kahlon, paragraph 20, that I remembered, my lord. Your lordship will kindly see paragraph 20 of Kahlon's judgment, Supreme Court.
19 and 20. Thanks, sir.
Paragraph 20.
20, your lordship, just read the first line, my lord.
Yes.
Head of pain and suffering being.
My lord, this is what I remembered out of my recollection, my lord. I could just point it out to your lordship. And my lord, subsequently, I have not searched, my lord, any other High Court judgment or Supreme Court. My lord, I must confess before your lordship. But your lordship will take note of that. My lord, this is what I know is the last Supreme Court. I'm not getting into the High Court, what High Courts have said, my lord. But my lord, Supreme Court
have agreed to what Supreme
then
Court
if
has
it is,
said.
my lord, if it is, your lordship will take note of that, my lord, and then while assessing your lordship,
The principle is that the heirs or legal heirs can defend.
yes,
Up
yes,
to
Can
one-
defend.
They can
Yes.
defend up to 135, and if, for example, multiplier is wrong,
Yes,
or
yes.
if the income is wrong, that
Everything,
they
all
can
merits are
enhance.
open.
But they
But
cannot
regarding the
enhance.
personal
Yes,
expenses-
they cannot enhance it.
Personal expenses on that point, they
Yes.
cannot.
lordship,
Yes.
lordship. My lord, so lordship will take note of that. I'm not telling your lordship with any further judgment. If my
Very-
lord so desires, my lord, then I'll come and assist your lordship. If my lord feels so, my lord. Otherwise, my lord, on the basis of Kahlon, my lord, I restrain
necessary.
myself.
Not necessary.
I'm extremely grateful.
And my lord, the Delhi High Court judgment, which I have handed over, my lord, that exactly, my lord will kindly,
my lord, I've not gone through this. Then, my lord, I could
No,
not.
no,
I must
I'm not-
confess.
it's nothing disputed. My lord, my lord will kindly see
Refer me the paragraph.
paragraph 5 and 6. This is the argument of the Supreme Court, which Mr. Singh had submitted, that future prospects and personal damages, whether it will be taken or not.
Paragraph 31 is for Carlin.
Yes. Now, my lord, kindly comes, it has discussed all the aspects, future prospect, whether it should be awarded or not. My lord will kindly come to paragraph 21 with regard to pain, shock and suffering, loss of amenities. Paragraph 21 at page 8.
Yes.
25 is the relevant paragraph. Following Kahlo, this is what Delhi High Court has explained. 25, it is reiterated that merely because the claimant has unfortunately died during the pendency of the present appeal, this would give no reason for the courts to reduce the amount of compensation. Life is uncertain and compensation granted on basis of certain assumptions and what is found to be reasonable in the given fact situation. The compensation awarded cannot be revisited only because later some event transpires which may be contrary to such assumptions. If this is allowed, there shall be no finality to an award. Even otherwise, the claimant would have suffered the pain and loss of amenities of life for these 7 years. Even these cannot be measured in terms of money. However, as compensation can be granted only in terms of money, I find the compensation awarded is reasonable and the same does not warrant any interference from this court. Exactly my point, my lord. One cannot enhance, but 135 has become a part of the estate.
Yes.
So to that extent, they are entitled to receive it, but it cannot be enhanced or it cannot be, if it can be reduced by your lordship, if your lordship feels so, but it cannot be enhanced under any circumstances.
Milord 26 is against Kahlon. The line what your lordship read. If Milord without reading it in its entirety, your lordship can you go to paragraph 26 of Delhi? It's against Kahlon.
No, my lord. In Kahlon, there the Supreme Court enhanced, High Court and Supreme Court enhanced the compensation. Here, the compensation is already awarded by the tribunal. 1,50,000, this compensation is awarded by the tribunal. The High Court did not change the award of the tribunal. Kahlon Supreme Court. Kahlon 1 lakh taka diyechilo. That was increased by Supreme Court to 28 lakh. Here the 1,50,000 was given. It has been 28 lakh. 1 lakh tribunal diyechilo. Supreme Court enhanced.
What is first line of paragraph 20 say? What does it say? Correct.
And awarded anything towards medical expenses.
সেটা বাদ দাও now. Pain and suffering disallowed. Supreme Court says. তাহলে এখানে pain and suffering কি করে দিল দিল্লি?
Because it has already been awarded by the.
Milord, your lordship will take note of that, Milord. Milord, without going through the judgment in its entirety, Milord, it is not absolutely correct on my part, Milord, to create dispute here. But Milord, Kahlon says first line, and Milord, then High Court says that no, it is giving pain and suffering, Milord. Your lordship will kindly take note of that.
Milord,
and future medical expenses as well, Milord.
This is the fine line difference, my lord. I am not asking for new medical expenses or new pain and suffering, loss of longevity. I am not asking for those. I am defending only what has been awarded, which has become a part of the estate of the deceased. The legal representative are only claiming through the deceased. I am not asking for enhancement. In Kahlo, the tribunal awarded only 1 lakh. The High Court enhanced it to 33 lakhs. Supreme Court reduced the pain and suffering, which the High Court had longly given, to 28 lakh. I do not dispute that. 1 lakh. High Court 33 court. Supreme Court says no, 33 এর মধ্যে pain and suffering and all you cannot give. That's why 28.
তো সেটাই তো বলছি, you are correct.
Because ওর মানা গেছে
Pain and suffering তো দিতে পারবে না, তাই দিল্লি তো দিল।
High Court এ ও তো বেশি ছিল তখন। Then award is fast. এই দেখুন এই প্যারাগ্রাফটা দেখুন।
7 years after the date.
No, no.
ওটা তো দিল্লি আছে, এটা
Hello, এটা 21 years after the accident.
হ্যাঁ, তা তো pain and suffering দিল না। In spite of suffering, pain and suffering for 21 years, Supreme Court still said not to be granted.
High Court did not.
Supreme Court said.
High Court did not give. High Court gave. But that he was alive then. In Supreme Court, her daughter.
That's what I'm saying. Yes, correct. Supreme Court said not to be given.
Yes, but এখানে তো আমার already award হয়ে রয়েছে। নতুন করে High Court দিয়েছিল। That Supreme Court says you cannot give.
What is the principle?
Principle is what has lower court given, that becomes the part of estate. In civil suit, যদি I am representing the estate, I can claim defend up to 135.
Okay, you read the Kahlon.
Yes.
Kahlon at page 195. what is the issue before the Supreme Court.
Yes.
Second page of the judgment. Before the second para. Before the Supreme Court in the present appeal, it is submitted on behalf of the appellant that the cause of action being the personal to the injured abates on his death, which was not caused due to the accident. The legal heirs is entitled only such compensation which forms part of the estate of the deceased. Loss of salary, future prospects, pain and suffering, along with attendance charges do not form a part of the estate of the deceased. This is the issue.
This
Yes.
was the issue. Exactly, this was
This
the
is the issue before the Supreme Court.
Yes, and I completely agree with that. I am not claiming any enhancement anymore on the grounds which I had argued before. But up to 135, which has become the part of the estate of the deceased, that I can claim. If that includes pain and suffering, I cannot claim enhancement, but I can defend up to 135. 1 crore 35 has become a part of my property. That's what the legal representative have devolved on them. That's all, my lord. I am not.
Okay,
Lord,
I
if
understand.
that is taken to be the logical conclusion that the paragraph 20 becomes infructuous of Supreme Court.
No, no, my
Court
lord.
says not to be given. That cannot be formed. That cannot be formed to be the part of the state.
Now, only in Kalan, Supreme Court perused that the pain and suffering was
That's what I.
given
That's what I say. Yes.
Yes.
without any recording by the High Court or what
Yes.
it is why
My
the said was enhanced from 1 lakh to 28 lakh.
Yes.
But
There is no
Calon-
observation like that.
Yes, my lord.
Lord-
What happened in
I
Calais?
shall read entirely, no
Yes.
issue. I
My
shall
lord,
read it.
what happened in Calais is 1 lakh was awarded by the tribunal. 33 lakh was made by the High Court,
Yes.
and pain and suffering and all was given. The deceased, after the death, husband, wife both died, and the daughter contested in the Supreme Court. Supreme Court says that the High Court, which enhanced the pain and suffering and all, that cannot be enhanced. I completely agree with it. I'm not asking for enhancement. But in Calais, 1 lakh was given only as the total award. But here, my award is 135. I have a right to defend that award. My lord,
Again,
will
my lord, I join issues, my lord, on the principle. Supreme Court on principle says it cannot be given. Forget about tribunal, High Court. On principles, this cannot be given.
my lord,
My lord,
let
in
Mr.
Calon,
Singh-
my lord, he died, my lord, as I, my lord, understood, he died 21 years after the accident, if I'm not wrong. Not even after 21 years, he suffered that. Supreme Court said it's still not intact.
No. My lord, let Mr. Singh go through the judgment. He will support my case. Because, my lord,
Not necessarily, I shall.
Lord,
permit.
Calais is
no,
conclusive, my lord.
It
Whatever,
was
my
1
lord.
lakh, thereafter it was enhanced to the 37 lakh.
Yes.
37 lakh by the Kalan
High
in
Court
the High Court.
And
And
reduced
now
to
Supreme
28.
Court says there is nothing in the enhancement of the pain and suffering.
Yes.
Even though he suffered for 21 years,
Yes.
he still said no, not entitled. That's what I say.
My lord, no. My lord, kindly understand one thing. The Mr. Singh,
Yes, Mr.
Yes.
Singh is on principle.
yes,
On
on
Of
principle,
course, I said I'm on principle.
whether Calais says I can defend my estate or not. Calais says yes, you can defend. If the tribunal gave me 1 crore 35, I can defend up to 135.
My lord,
If your lordship feels that no, pain and suffering I'll not give for the person who has suffered, my lord can do it. But up to 135, I have a right to defend.
Sorry, I shall look at it. No issue. Please take down. So you have can 3 and what is the number of can, another can?
Can 1. In cross objection, my lord, it is can 1 of 2024.
Yes.
In FMA 313, the can number is can 3 of 2024.
Actually, can 1 of 2024, can 3 of 2024. This is an application for substitution filed by the petitioner. It is Mr. Mondal and a counsel appearing on behalf of the petitioner submits that during the pendency of the argument of this matter, the petitioner claimant expired on
My lord, he has expired on
19th of July 2024.
24.
Full stop. Living behind his widow and his daughter. This is the Mr. Monroe submits that. This is an application for substitution. The present petitioners are the show the only legal heirs of the deceased claimant. So they require to be substituted at the place of the deceased claimant. Heard the learned advocate peruse the copy of death certificate and the other documents connected in respect of the petitioners. It further appears that that Mr. Mondal has represented. No, it further appears that the petitioners are represented through Mr. Mondal and Mr. Paul by filing a fresh PAR. Considering the same, the CAN 3 of 2024, CAN 1 of 2024 as well as the CAN 3 of 2024 are considered and allowed. The
Let the department carry
present
out the
petitioner
corrections.
are being substituted at the place of deceased claimant respondent in
Number
the
one.
FMA and appellant in the cross appeal.
My lord.
The department is directed to carry out the corrections in the memo of the cause title of the appeal as well as the memo of the cross appeal within a fortnight. Now, this matter appears on mentioning, though the matter is placed for CAV. Last let the matter be placed under the no. Then let the judgment be reserved. Made CAV.
Deeply obliged. Extremely grateful to my lord.
I appear for the state, my lord. This is for extension of the interim order, my lord. Affidavits are complete. My lord, I am only praying that the matter be fixed on a particular day, my lord, because they are enjoying an interim order which is in the nature of a final order, my lord. That order of termination has been stayed.
You have filed the affidavit?
Yes, my lord. Affidavits are exchanged.
And exception? Very well.
Reply.
No.
Reply.
Please take down.
No, we have not filed a reply, my lord. We have not filed any reply.
Do
Personally,
you want to file any reply?
no, I have not.
Okay. No, you have not, I understand. Do you want to
I
file?
will.
You shall file.
My lord, let the direction be made peremptory because affidavit is not.
Very well, I am fixing the date. No issue. This matter appears under the heading of 2 mentioned. Learned counsel appearing on behalf of the petitioner submits that this court had passed the interim order on 3rd of May 2024. The interim order is going to be expired. So he prayed for necessary order for extension of interim order till the disposal of the hearing of this matter. Next, learned counsel appearing on behalf of the state submits that the pleadings have already been completed. So necessary order may be passed fixing the date of hearing of this matter. Or the learned advocate considering the submissions. No, learned counsel for the petitioner submits that
The exception filed.
he may give in a liberty to file the exception to the report filed by the state. Yes, anything?
No, ma'am.
Okay, exception to the file the state. Let the matter appear in the list under the heading of hearing on September 11. September 11, 2024. Full stop. Next file. The interim order passed by this court on the earlier occasion is further extended till 30th September or until further whichever is earlier. Full stop. The petitioner to file the exception, if any, within the adjourned date positively.
My lord,
11.
the direction.
Because he is enjoying the interim order. The time
What you want?
earlier also it was extended the time to file the reply.
Yes. So what you want? I have
The direction to file the reply is peremptory.
yes, positively within 11th.
Yes.
within the returnable date. With the urgent date, the matter will be taken up on the urgent date.
Yes. My lord is fixing the matter.
Fixing the matter for hearing
Yes, my lord.
on 11th.
Yes.
Interim order was extended till 30th. If the matter is disposed of earlier than that, then the matter will be go to.
Good.
Yeah.
This is a correction of your lordship order. My lord. The recording of the WPA number has wrongly been recorded. And it should be Kanailal Bhomik, it's Kanailal Samanto instead of Joyanto Bhomik, it has been recorded. And WPA number has also been wrongly been recorded.
What is the WP number?
18890.
Yes, 1890 is the order.
It has been recorded 18892 in the server. In the server, it is 18892.
Okay. So, what is the name of the person?
Kanailal Samanto.
Yes, it is
But
correct.
it has been recorded Joyanto Bhomik in the server. In the server, we are getting on a Joyanto Bhomik and Kanailal. But this is
Subsequently corrected, I think.
বারবার হয়েছে কি ডব্লিউপি নাম্বারটা আলাদা নামটাও আলাদা
Are you
এখানে তো ঠিকই আছে এখানে
So possibly, my lord, on the same day, numbers of matter move. But from the server, it appears another order.
18892.
So both,
এটাকে
the other
আপলোড
matter is concerned, there is
ডাইরেকশন টু আপলোড
everything all
দিস
right.
আপলোড দিস অর্ডার ওয়ান্স
এটা upload করা যাবে না তো?
এটা আপলোড একটু করে দেবেন তাহলে
So it may be uploaded then.
Okay, okay. I'm giving that.
ওই অর্ডারটা দুবার আপলোড হয়ে গেছে দুটো matter.
Please take down. This matter appears for correction. Learned counsel for the petitioner submits that a wrong order was uploaded in the server. Uploaded in the server containing the number and number of the writ petition and the wrong name of the petitioner. However, in the order book, the order dated 30th July 2024 appears to be correct. However, the petitioner is directed. No, however, let the order dated 30th of July 2024 along with this order be again made server. Again made server.
So in this matter, I am appearing for the writ petition. The lordship kindly consider the last order passed by your lordship. This is a with regard to alignment of the wheat in favor of the flour mill.
Lordship, I am appearing.
Okay, order of the division bench was there.
Yes, ma'am.
And you were saying that one inquiry is required.
Inquiry conducted.
Inquiry has been
Inquiry
conducted.
conducted.
Inquiry has been
He
conducted.
participated in the inquiry
He
process.
participated in an inquiry process. Lordship asked me to come with the written instruction.
Okay. So this is the report. They have conducted the inquiry and have proceeded to giving you the allotted quota of allotment.
Allotted quota. I can directed them to give the quota from the month of September.
Let it be kept pending.
Yes, my lord.
Keep it pending. And
Lordship, they have taken an undertaking that this whole process will be completed within 2 weeks.
yes,
Allocation. This was the undertaking they have
after
taken.
2 weeks, I'll fix the date after 2 weeks. Okay. Please take down.
Does it kindly give direction to make the allocation for the month of September? Because my agreement is to the in the month of April, man.
No, this is the this is the communication dated 17th August.
August,
17th August. They seek 2 weeks. So I think that it would be completed within this first week of September.
First week of September, it should be
They would complete.
No, man. I have agreed with the lawsuit view, but I want to say, man, kind of directed them to allocate allocation made
For the September, for the month of September.
Month of September.
because
Why, my lord? My agreement was executed in the month of April. April, May, June, July gone. 4 months gone.
I understand. I understand.
Agreement for 1 year, madam. So I prefer kindly give them direction to allocate the quota for the from the month of September.
I will humbly beseech your
For
lordship.
the month of September, quota has
Kindly let me-
not yet been released, madam.
Kindly let me make a submission, lordship. I humbly beseech. This is a humble suggestion that after 2 weeks, your lordship, because the entire process has to be let the process be completed. After 2 weeks, if the process is not complete of the allocation, if they don't start the allocation, then your lordship might. Because
No, my lord, what happened? I can say it to you, lordship. They complete the process, but give the allocation from the month of November or December.
after the process is completed, we are bound to give.
Yes.
Now, bound to give from a what month?
Okay, okay, okay. Learned counsel appearing on behalf of the state submits that as per direction of this court, in pursuance to the direction of this court, the authority has made an inspection at the mill of the petitioner, wherein the petitioner was present. The milling capacity and other capacity and automatic packaging capacity has been noted by the concerned authority during the course of inquiry stroke inspection. He further submits that the authority seeks 2 weeks time for completion of process of allocation for allotment of quota of the said flour mill. Learned counsellor hand over the written instruction of the concerned authority. Peruse the written instruction. Full stop. Written instruction dated 17/8/2024. Full stop. Learned counsel for the petitioner submits that a specific direction may be made to the concerned authority so that the quota of flour of the mill of the petitioner be given from the month of September 2024. Full stop. The concerned full stop. Heard the learned counsels peruse the written instruction of the district controller, food and supply Virbhum. It appears that the concerned authority has conducted inquiry and sought for accommodation of 2 weeks for completing the process of allocation. The 2 weeks completes with the end of August to August 31st. So the full stop. The meal full stop. The direction of the Honorable Division Bench is already there to provide the quota of atta, quota of wheat, quota of wheat in favor of the petitioner. Considering the situation, the authority is directed to complete the process of allocation of wheat in favor of the petitioner and allocate the petitioner the quota of allotment for the month of September, quota of the allotment, if possible, from the month of September 2024.
Much obliged. Don't record it my email because quota for month of September not yet released.
Your Lordship,
Not yet released.
kindly go through the instruction after.
If my
getting-
learned friend show the document, the quota of the month of September has been released, then I can go out to court, my lord.
Lordship, he has to complete the necessary formalities.
Yes,
थाने का setting is open, I might get to.
preferably from month of September.
Yes,
That's why I'm saying.
Much obliged.
I know,
Preferably from month.
what is the formality?
I say the 31st is the last day of the 2 weeks. So they should issue the allotment preferably from the month of September 2020.
The difficulty being, your Lordship, very candid submission. In the instruction is written, they have to submit bank guarantee and other
Bank
formalities.
guarantee can we submit within 1 day, man? Within 1
If
day.
they submit it, then there should not be a problem. But these are formalities which they have.
Only one formality is there, only submit the bank guarantee. Bank guarantee can be submit within 1 day, man.
Should I pass any audit?
Your Lordship,
Bank guarantee can be submitted within 1 day.
Then you provide the bank guarantee.
Yes, my lord.
let them provide, because
I can.
No, if you are not required them, so how can they provide the bank guarantee?
My lord, what is the practice? District controller wrote a letter, give me direction to submit bank guarantee within 7 days or 10 days. My client willing to ready to submit the bank guarantee within 3 days. I know what is the procedure.
Completion of 15 days, thereafter 3 days, 1 week, how can we?
Lordship, I am not aware of, like my learned friend is aware about the procedure. I'm only acting on I'm a creature of the instruction only. I'm acting on the basis of the instruction. Instruction says that necessary approval from the department. So there has to be internal some procedure is there. That's why he's asking for 2 weeks time to
Yes.
complete the procedure. That's what I have to submit, your Lordship.
Let it be there.
Now,
Let the matter appear in the list on 4th of September.
now, my lord, what happened? I got tell you, lords.
Yes.
District controller wrote a letter to me on 2nd September, give the time to submit bank guarantee within 10 days. They see your lordship. I know.
Then you submit the bank guarantee on the next day.
Next day he has said it.
He wrote a letter on 2nd. Before wrote a letter to me, he released the quota for the month of September.
Lordship, let's not go to conjectures and surmises.
Yes, yes.
Much obliged.
Let it proceed. Next.
54, my lord, I am appearing on behalf of the state, my lord. I'll be paying for extension of time filing. The last petition I filed in the order. File a report in the form of asking for that extension.
Like usually, my lord, Project Datta. If your lordship recalls, my lord, may I, my lord, very briefly, my lord. Lordship would recall, my lord, this is the case, my lord, where, my lord, I have been tagged with the Raj FPS, my lord, of a town in Charbajitpur, my lord, and my lord, the FPS goods of both the places, my lord, are being, my lord, delivered at my godown, for which, my lord, I have to travel in trucks till the river bed, my lord, then
One river,
boat,
crossing the river and
river,
the, okay,
and then
okay,
again
I understand. I understand.
So lordship had, my lord, on
I
their
understand that
prayer.
issue.
Your lordship would recall, in fact, I thought he's asking for 2 days. I said, I'm not opposing. Lordship gave him 2 weeks. And my lord, again, my lord, the position is the same, my lord.
There was a approval. Approval is already there for notification of vacancy. But I have to disclose the status.
No. My lord, the last order says, my lord, let the advocate appearing on behalf of the state submit that he needs necessary instruction for the authority concerned in respect of prayers B and C. My lord, prayer B and C, my lord, is either, my lord, I get, my lord, the FPS goods at both my godowns, which the law says that it has to be doorstep delivery. I had shown the provision, my lord. Or, my lord, it has to be tagged with the nearest. The nearest. And I'm not the nearest, my lord. The nearest one is, my lord, one Muslima Bibi. Lordship had asked me, my lord, to take instructions, my lord. Muslima Bibi, having her FPS shop, and she is more than happy to be tagged. We've spoke to her and she's happy because hers is the nearest one. So, my lord, there is no.
Every month he is suffering a lot
Yes.
of money.
Yes. Forget about the hardship.
Let me come up with the
Next week.
Lordship will not. This suffering has been going on. Lordship had considered this, my lord. And what will happen, my lord? Either it has to be Lordship's order, my lord. Either in terms of prayer B or prayer C. That was their instruction. But they will either concede to prayer B or prayer C.
Yes, well, for the next week. That's why.
Kindly give us a between
28th. 28th is the worst day.
Yes, my lord. 1 week would be 28, my lord. In fact, I would pray if it can be taken up, my lord,
Sorry.
before 28.
Please take down. Learned Council appearing on behalf of the state submits that 6 an accommodation for extension of time to submit the report. Learned Council for the petitioner submits that the petitioner is suffering day by day. Due to the inaction of the state authority. However, considering the submission, the state is directed to submit a report. State authority is directed to submit a report on 28th of August.
Can I get an advance copy, my lord? Is it?
Let the matter be appear on 28th August under the same heading.
I'll take to the next.
I hope this direction is peremptory, my lord.
Yes, yes.
That is fixed. That's why the direction is obviously peremptory.
Yes.
Next.
For the petitioner. Last question, my lord.
For the respondent number 8.
Private respondent. The challenging the selection process made by the HPCL in connection to the dealership of the.
I am for the respondent number 1, formal part. Made by DSP.
Even after several irregularities which has been mentioned by us through various communication, but they do not pay any heed over that.
What is that?
Let my senior.
HPCL. Who is
HPCL.
appearing for the HPCL? You are appearing for the HPCL. Very good. Yes.
Well, then without affidavit, this matter cannot be decided, my lord.
But then, my lord, stay their hand from taking any decision regarding. Well, if the submission, if the submission of the private, if the
should be decided.
well, if the submission of the private reason to that effect, then my lord.
Let me hear out. Let me hear out. I have the time. Let me hear out.
Yes. May I submit first?
Let me hear out the petitioner. Otherwise,
my lord, first of all, my lord, on 18 July 2020, an advertisement was published by the Hindustan Petroleum Limited Corporation for appointment of the retail outlet dealership. Kindly look to the advertisement which is at page 20.
Yes.
Page 20, this is notice for appointment of regular and rural retail outlet dealership. Hindustan Petroleum Corporation Limited proposes to appoint the retail outlet dealership dealers in the state of West Bengal as per following details. Now, my lord, kindly come to the relevant page which is at page 23. Page 23.
Yes.
Page 23 is serial number 114. This is the subject local where the petitioner applied, also the private respondent applies. This is within 2 kilometers of Jhorira High School on Saltora of the Jhanti Pahari Road. And there is a, my lord, in the advertisement, there is a specific stipulation in terms of the frontage and depth of the land which will be offered by the participant. Kindly see, my lord, the page 20. Kindly come again, my lord, come to page 20, heading frontage and depth, middle portion. Serial number 8, 7 and 8. Depth and frontage.
Yes.
The land which will be offered by the candidate, it should be 30 meter 30 meter frontage and 30 meter depth, which is at page 23. Kindly see 30. Both are 30. Now the petitioner participate page 35. This is the online
What does
application.
mean frontage means?
Frontage means
Front.
just in front
of
roadside,
the
roadside
site.
frontage.
Front of the site.
Roadside frontage.
Okay. Frontage.
Guideline if your lordship recollect in the Agamata as against your lordship, these tender conditions are guided by National Highway Authority. In case of to avoid all accidents and all, there are certain guidelines which are framed by the National Highway that these are the stipulations which you have to consider, then I can.
Frontage should be 30 meters. At least
Yes,
30.
yes.
Avoid accidents of all those things.
Kindly see my application form, which is at page 35.
Yes.
This is the application form filed by the petitioner, and he offered a land, page 36. That is similar description as
That is
on
the application for the petitioner.
petitioner. Now, my lord, kindly come to the brochure of the respondent authority, whereby the relevant portion is at page 42. Kindly see, my lord, 42. What type of lands the participant can provide at the time of application? There are 3 types of land. Group 1 land belongs to applicant having suitable piece of land in the advertisement location area, either by way of ownership, long-term lease for a period of minimum 19 years, 11 months, or as advertised by the OMC. Group 2, the applicant having farm offer for a suitable piece of land for purchasing and the long-term lease for a period of minimum 19 years, 11 months, and as advertised by the OMC. And Group 3 land, applicant who have not offered the land. Here, my lord, the applicant and private respondents applied in respect of Group 1 land.
Okay.
Now, kindly see, my lord, the relevant portion, another relevant portion, which is at page 65 of the brochure, which is in respect of the land evaluation. The procedure of land evaluation is mentioned there, to that effect that the concerned divisional, regional, and territorial office shall inform the provisionally selected candidates through mail, SMS, at least 10 days before the day of visit of the LEC for site evaluation. That is, there is a provision of site inspection. In the case no response, non-availability of the provisionally selected applicant, the candidature shall be cancelled under the intimation of the provisionally selected candidates through SMS and email. Roman 1, evaluation of the offered land will be carried out to ascertain the land being a advertised area and the suitable for development of retail outlet meeting norms. The parameters under which the offered land will be evaluated by the land evaluation committee. There will be a evaluation committee who has to justify the prospective of the land which is offered by the participant in terms of the advertisement. Now, my lord, the point, land falls within the advertised area. Now, land, this is the Roman, the first option, land falls within the advertised area and sketch as on date of the advertisement. That is vital. Now, kindly see the next provision, which is at page 66. Top paragraph. In case offered land is found to be suitable, then LEC will submit the recommendation to the divisional, regional, territorial head for carrying out EVC for the provisionally selected candidates. And in case the land is not suitable, here, my lord, the crux of the matter, the land offered by the private respondent is not at all as per in terms of the eligibility of the advertisement. That is the contention of the petitioners. Now, kindly see, in case of the land is not suitable, then provisionally selected candidates will be informed about his or her ineligibility and rejection of his and her candidature, the selection process will be continue with the balance of the candidates. The petitioner, my lord, second in the panel. My lord, what is it? They published a list of intent. Letter of intent has been issued in favor of the private respondent, in spite of giving the ineligible deed of conveyance. In terms of the advertisement, they did not meet up the condition of the advertisement. Now kindly come to the provision of next provision.
What is your ground here? Ground for challenge?
The land offered by the private respondents is not in terms of the provisions of the advertisement. The land shortage of 30-meter frontage and depth.
So
And there is a
have
wrong.
you given anything in your writ petition?
Yes. Kindly see, kindly look to my lord, page 66 once. The letter of intents.
No, what is the fact? See, he was selected provisionally.
Provisionally,
Law
letter
blocks.
of intent has been issued in this paper.
Letter of intent was issued.
But the deed which is offered by the private respondent, this is not to the mark of the eligibility of the advertisement.
This is only your ground.
Ground.
Contention, my
Only
lord.
contention.
Private respondent, my lord, being the respondent number 8, offered the land, that is shortage of the quantum of the land.
No, description also.
As per the advertisement. His
Schedule.
schedule 30 meter is, my lord, the shortage.
My lord, schedule is also wrong. Kindly see, my lord, one by one I am coming.
Then
Kindly
it has
come
to
to.
be ascertained without affidavit. How
Yes,
can
my
I?
lord, that's a.
Well, in the meantime, no appointment should be given in respect of
how
this
can-
election. If
They have already issued LOI.
LOI is not. LOI is not.
I understand. There are some process to be adopted after LOI.
Challenge the maintainability.
Well, in the meantime, even the affidavit, my lord, is given, give direction as given, and in the meantime, outcome of the petition, but the appointment shall be stayed.
How can that be so?
Until unless, then my lord, the right of the third party will create it.
Law is very clear and well settled today.
Well, when my lord, I am, kindly see one, kindly,
will interfere in the tender process.
kindly see the deed of conveyance which is given by the private respondent.
You show me. Okay.
Yes, kindly see. Kindly see.
Page.
Page-
Page. I can show it's not intended.
Page 80, kindly see the page 87, the deed. I have annex. This is a deed of lease executed by one Srimati Momota Chatterjee, Sri Joydeep Chatterjee, then 3 Srimati Mo Mukherjee, next page, and Srimati Piu Mukherjee. This is a deed of lease in favor of Gautam Majhi. Private respondent Gautam Majhi. No. Gautam Majhi. And Pintu Mukherjee. Kindly see the 4%, my lord, given leased out the land in favor of Gautam Majhi and Pintu Mukherjee in terms of the deed executed on 5th day of April 2018. And kindly see the 93, kindly see the schedule of the property.
বলুন না ঠিক আছে ওর মতো বলুন না না ও তো জানে না না জেনে বলছি ইজ নট অ্যাওয়ার অফ
Total area of land, district Bakura, PS Chatna, the jail number 31, Mouja Parashia, the now total area of land 0.32 acres out of classification, out of which 0.22 acres of land. And kindly see the schedules.
0.22 acres of land.
Land. Now kindly come to page 129. The records of rights in respect of the subject property which is leased out in favor of one in favor of Gautam Majhi and Pintu Mukherjee. Kindly see my lord 129. Now in respect of the dag number 495, Khotiar number 490, last 495 at the bottom, page 129. Kindly see the last dag number, Khotiar number 495. And kindly see the owner's name, Momota Chatterjee, and next page, Joydeep Chatterjee. The total area of land 0.22, 0.11 plus 0.11, both Joydeep Mukherjee and Joydeep Chatterjee and Momata Chatterjee. Kindly see the last bottom 129.
129.
9 Khotian number 495.
In the name of
Momata Chatterjee, and kindly see, my lord, where next page 496 Khotian number in favor of Joydeep Chatterjee. Now, my lord, he has given the lease declaring there are 4 owners. 4 owners, namely, kindly come to the, again, my lord, kindly come to, my lord, page 87. In terms of the record, the land is, my lord, 0.22. Now they declare the total land 0.32 in the deed of conveyance. Page 87. Kindly come now, my lord, come to page 87. In terms of the deed of conveyance, there are 4 owners, but the records of right says, my lord, there are 2 owners.
Why record of rights 2 owners?
2 owners. Kindly see page 129.
In the plot number 901, there are 1, 2, 3, 4, 5, 6, 7.
No name of those 2 remaining 2. P.U. Mukherjee and Srimati Mo Mukherjee is not there.
You cannot run like that. Total area is 46 decimal.
That is separate. Kindly see Khotian number. Kindly see the schedule of the deed. Page which is at page 20. Kindly see page 93. Page 93. There is a Khotian plot number 901 and Khotian number 4/3. Total area 0.32 acres. They have stated in the deed of conveyance. The property leased out by 4, and the records of right says that the owner is 2. And kindly come to the subsequent lease of deeds which is published, which is submitted by the private respondent, which is at page.
If their title is not correct, they would be automatically ousted.
But that's why, my lord, I filed the petition.
That is the
browser. But let there be an investigation by the authority, selection authority.
Sir, investigate the issue after the process of LOI. Very well. I find nothing to pass any interim order. You file the affidavit. Okay, please take down. Having heard the parties, it appears to me that the incident matter cannot be disposed of without giving opportunity of the parties to file affidavits. The respondent number HPCL 22,
2, 3 and 4.
2, 3 and 4 is at leave to file the affidavit in opposition within 4 weeks. Within 4 weeks. Full stop. The respondent number private respondent number 8 is also at leave to file the affidavit in opposition within 4 weeks from this date. Exception there too.
But in the meantime, my lord,
if any, by the petitioner within 2 weeks thereafter. Full stop. Considering the Considering the entire facts and circumstances of this case, I find no justification to pass any interim order in this matter.
But any result, my lord.
Point of maintainability.
Any result in the meantime, my lord, any result in the meantime will be abide by the result of the writ petition. But that can be because, my lord, they describe the Khotian illegally. There is no mention.
When you issued the LOI.
LOI I have annexed. Kindly see page 85. Page 85, they have issued the online information on 15th March.
Already March. Okay. I find no justification. Very.
Obligement.
জানি না, তুমি মেশিন নিতে পারে আগে, আর ঘন্টায় করে।
My lord, I have to private school. I oppose it. Because my lord,
Remember, vacancies for there. One of the
my lord, your lordship directed them to mandatorily come up with a report within 7 days. Now, my lord, I am suffering from the very beginning, 2023 matter, division bench direction, my lord. My lord, no, my lord, kindly do, does not. Kindly does not, my lord.
Legal heirs of the and it is the submission of the private respondent that the he was license was granted apart from anything.
Now, my lord, I am, in spite of getting a license, my lord, I am. My lord, fixes it on 27th, my lord. Kindly, because 2 days they will give, they will.
You also have to report whether the cards which was allotted to that person, whether that is separated from the, that is erstwhile previous or not. That has to be.
My lord, may I recapitulate, my lord, on the earlier direction, your lordship directed it, the square of the report is that there, if vacancies were allotted to Lokhinarayan Datta, the heirs of Lokhinarayan Datta, then there will be 1500 cards left. What will they do with that 1500 cards? With regard to that only the report, with regard to that extent only the report has to be given, not other issues, my lord.
However, one report is required.
With regard to 1500 DRCs only. If suppose my vacancy is also there,
that one may be there.
My lord, may kindly extend 2 days time. 9th and 11th. 9th and 11th. What will they do with the 1500 raised DRC? With regard to that only the report was called for. Suppose my vacancy is also opened and the heirs of Lokhinarayan Datta also gets the vacancy, then what will they do with the 1500 DRC?
So what? How many time?
No, my lord, kindly fixes it on 27th. They are getting a 2-day time. They. My lord, kindly fixes it on 27th, my lord. No, my lord, my lord, I am suffering, my lord, kindly see there is a case. My lord, suffering for a year doesn't entitle me to suffer for 2 weeks also. Actions of the state makes me suffer, my lord.
Okay, come on 3rd. Come on 3rd of September.
My lord, kindly makes it then 4th.
4th. 4th is the day.
Or makes it 2nd, my lord, whatever your lord.
2nd, 3rd will be fine, but 4th, very well, 4th. Okay. Please take down. And the learned counsel appearing on behalf of the state seeks accommodation to to extension of time to submit a report. Accordingly, the accommodation is granted. The state is to submit a report as mentioned. Submit a report in pursuance to the direction of this court dated 12th of August 2024 on or before 4th of September 2024. Let the matter appear in the list on 4th of September under the same heading.
My lord, kindly makes it direction peremptory, my lord, because again they will come up, take action. My lord, kindly makes it direction peremptory, my lord.
If they not appear with this report, I shall hear the matter of.
One matter, item 20. For today, Starling from but due to illness.
Item number?
20.
My lord, in this matter, I have been engaged to argue on behalf of the review petitioner. My lord, the
7.5 of 2020.
Review application. Yes.
Kindly take it up on
day after the next week.
Day after tomorrow is not possible.
In next week, your lordship, kindly. I don't have any objection if my lord, my learned friends, my lord.
You are appearing on behalf of
I
whom?
want to review petition. I have been engaged by Mr. Shima.
Okay, okay, you are there. Very.
30 or
No.
No,
28.
28 at 2 p.m.
28 at 2 p.m. 28 at 2 p.m. 28 at 2 p.m. Call the list.
এইটা তাহলে অর্ডার করে দিলে আমাকে আর নোটিস করতে হবে না বলবো
মানে সিমটিসিটা একজন মানে ফিক্স অন
Yes, on 20.
All. I'm very sorry to. Item number 8. I found that your lordship has a very busy list today. More than 7 matters to step to. So most probably, and for original side matter, your lordship will take it up. So most probably, item number 8 may not be called today. May not. I'm not sure, but may not be called today. On that occasion, if your lordship diary permit lordship measures to fix the matter any other date, because your lordship may not be taken up. Any other date on the next week.
If it is not heard today, it will fixed on next week. No issue. Next week. Okay.
Friday, tomorrow and day after are not there.
Thursday and Friday, group 6 matters will be there. Okay, please proceed.
My lord, I am for the petitioner, my lord.
You are for the petitioner.
Petitioners, my lord, were initially engaged as part-time lecturers of various government polytechnics over a prolonged period of time. In 2010, my lord, a memorandum was issued by the government by which, my lord, they were given the status of contractual fixed remuneration employees. So they were brought under fixed remuneration and contract. But the suffix of part-time remained. 2010, before that they were part-time, admittedly. 2010, a notification comes for this category of lecturers. They are introduced as contractual fixed remuneration employee of part-time lecturers. So contractual fixed remuneration, monthly remuneration comes in. After that, my lord, there was some discrepancy whether they will be governed by the previous part-time circulars or new circular. That was clarified that they will be governed by the lecturers of polytechnics.
Polytechnic college.
Polytechnics.
Okay.
Government polytechnics. Now, my lord, 2010, this circular comes. Their service is governed separately under this. And clarification comes that they will be governed by this circular and not the circular governing the part-time teachers. I'll place these 3 circulars. I'm just giving the gist of the matter. After that, 2011, my lord, Finance Department, my lord, brings in a circular not to give security of tenure and my lord, fixed remuneration to various employees not engaged in the various departments of the government. That is for casual and contractual employees. This was from 2011. It was enhanced from time to time. 24 is the last enhancement. Fixed for 5 years. This is a contractual sum. For 10 years, this is the sum in this manner. And group D, group C, various groups.
Yes.
We say that initially we were part-time, but in view of our engagement as contractual fixed remuneration employees, our status has changed to contractual employee, and we are eligible to get the benefit of the government circular, which the government has given for all the departments. This is a general circular of the finance department. We are governed by that. That is the my lord, case made out here. Subsequently, my lord, they have in 2021 they have give us some benefit, limited extent benefit has been given to us, but not commensurate with the my lord, finance department's benefit, which is universal
Happening circle.
for all departments. So that is the grievance of the petitioners, and they are discharging the functions similar to the full-time employees. We have given a list of function discharged by them, which has not been specifically disputed by the respondents. They say that they are part-time, but no specific denial of the functions rendered by us. So this is the crux of the matter. The first circular of 2010 is at page 34 of the writ petition.
So what you want?
I want, my lord, the
Status of contractual or part-time?
I say, my lord, that the status of contractual has already been conferred upon us by the 2010 circular. I want, my lord, the benefit of the 2011 circular of the government, finance department.
Received any benefit as part-time lecturer?
Part-time, the finance department circular doesn't, my lord, mention the term part-time. It says casual, deliberated, contractual. These three categories are getting. Part-time is not.
Earlier notifications, you have received the status of part-time lecturers.
No, contractual lecturer. From part-time, we have shifted to contractual. Admittedly, not by their own circular. We were part-time, we were engaged as not contractual fixed remuneration, part-time lecturers. The suffix remained, but
part-time is remain.
Suffix remains part-time. But if it is contractual fixed remuneration for the employee, they are getting a fixed remuneration for the entire month. That means he's getting paid for the holidays also.
What is the principle? You cannot be a part-time or contractual at the same time.
At the same time. And since you have brought us under a contract, monthly contract, you cannot call us as part-time. This is one. Secondly, our nature of duty. We have to attend from 10 to 4:30 or 5 in the evening. So nature of duty and the number of classes we are taking is more than the regular employees.
That is not denied specifically.
Not specifically denied. So that, by that way also the principle of equal pay for equal work, which is not now in the Jagjit Singh's case, the Supreme Court has not clarified that you are entitled to at least the basic pay of the regular employees if you are discharging the similar functions. So that is also not one limb of argument. But my first argument is not the finance department circular, which is applicable to us.
So what is the AO of the state?
Now, state says that since the suffix part-time is there, you were part-time and you are still part-time. Okay. So you will not get the benefit of 2011 circular. That is not their sum and substance of their defense.
And what is the private respondent?
No, they got added, They are similarly
added respondent.
By the same member, we are also appointed as a part-time permanent teacher. We come on a petition as we are the approval by the same member. Kindly come to my lord.
No, they are here with the memo wherein they are not they are denied as a contractual employee.
Yes, well, they have not
benefits of contractual employee.
There is no specific
So
memo.
why you are here?
We are performing the same duty by the memo.
Which memo which they have challenged?
No, we have not challenged any
memo
specific.
say-
No, we have not challenged any specific.
You are
memo.
not challenging,
We
you are asking the benefits of the
finance department's memo.
But the said memo is in respect of the contractual,
Deliberated, contractual, and casual.
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 So they are the permanent employees. So why you come under this provision?
By the same memo, the petitioner, we have approved in the same case. By the same memo, kindly come to my.
No,
Civil
who are you?
permanent. Permanent.
You are the permanent employees. So how you come under this purview of this notification?
Part-time permanent.
They say that they are similarly placed and they are entitled to similar benefit. That is not sum and substance of his case. Possibly they want to show that they have.
You also want the benefit of that circular. You also want the benefit of that circular. Okay.
Of the
just
finance
wait. Let me-
department.
let
This
me
is not a
start
sum
the-
and substance.
Okay. Well,
Now, Lord, may I just place the memos?
yes. Place the memo first.
Kindly come to page
Initial
34.
memo of your appointments.
That is, my lord, before page 34. That is also there, my lord. We have been appointed. That is not disputed. That is from page 30.
Show me the
Page 30. Page 30, my lord.
page 30.
Yes. Initial. Some of them, my lord. Approval of engagement is accorded, page 30. Accorded in favor of the following incumbent to act as part-time lecturer of Acharya Jagadish Chandra Bose Polytechnic, Barachapa. This is not 2003. Prior to 2010 memo. Some of the petitioners are there.
Lecturer.
Part-time lecturers. Initial engagement. Then page 31, 32. 33 also.
31, 32, other
30
petitioners.
30, yes, my lord, other petitioners. All of them, my lord, all the petitioners we have not annexed, but not admitted. They are not disputing that initial engagement was part-time.
Part-time lecturers.
Initial engagement, part-time lecturers.
Very well.
Then, my lord, comes the memo of 2010 at page 34. Annexure P3. Subject is implementation of contractual fixed remuneration of part-time lecturers.
Yes.
And other categories of employees of government, government-sponsored polytechnics. So they are implementing contractual fixed remuneration to the part-time lecturers. So we were part-time, now they are implementing contractual fixed remuneration. Now I am reading this memo. Undersigned is directed to say that upliftment of financial status of the part-time lecturers and other categories of employees of government, government-sponsored polytechnics in the state who have been rendering their service as such for long years was under consideration of the government in Technical Education and Training Department. After due consideration of the matter in supersession of this government department's GO number 534 dated 31/7/2009, undersigned is now directed by order of the governor to say that the governor has been pleased to implement the contractual fixed remuneration of the part-time lecturers.
Contractual fixed remuneration
of the
part-time lecturers.
Part-time lecturers. So they are now introducing contractual fixed remuneration for the lecturers and other categories of employees. Then not they give not the for rendering less than 4 years 10,500, 4 years to 10 years is 12,000, over 10 years is 15,000.
Yes.
This is 16/2010, no enhancement. Continuing.
2nd September 2010.
My lord. Now kindly come to the next page, my lord. Other terms and conditions in respect of such part-timers shall be decided later on. But they don't decide anything. Page 35. Then lordship kindly comes to page 38. And the government, the Director of Technical Education directs the various departments principals to implement the contractual fixed remuneration of part-time lecturers immediately. So 557 is implemented by direction of the Director of the Technical Education.
That means implementation of the last.
Yes, page 34.
Page 34.
Page 34.
Direction for implementation of page
34. In terms of this, my lord, we are all not engaged. We have annexed those papers, my lord.
Implementation of a contract.
Then, my lord, kindly comes to page 39.
Yes.
Here, my lord, there was a dispute regarding the memo, how, my lord, they shall be governed. There was a memo of 2010-675, which subject was engagement of part-time faculty and non-teaching faculty in polytechnic on hourly basis. The undersigned is directed to refer to his letter dated 15/7.
You are reading page 39.
Page 39, my lord.
What is this?
This is, my lord, the memo by which the Joint Secretary to the Government of West Bengal lays down how, my lord, the part-timers shall be paid.
Engagement of part-time faculty
on hourly basis
and non-teaching faculty in polytechnics
on hourly basis. This
on
was not
hour basis.
because this is their case that only hourly we go, we are engaged. That as per 675. This was later on clarified. That only hourly, because the case is that we are part-timers because we go for a particular time, we discharge our duty, we come back. So you are not full-time employees. And we have annexed the timetables. In the morning also we have classes, our name is in the timetable. We have annexed that. So throughout the day we are discharging.
What is the memo said about?
It says, my lord, kindly come to, my lord, the second paragraph. After careful consideration and for smooth functioning of polytechnic system, government has been pleased to revive the engagement of part-time faculty and non-teaching faculty in government-sponsored polytechnics on hourly basis. That is rupees 150 per hour per class, respectively, in case of extreme emergency, to be decided by the Director of Technical Education and Training on the following conditions.
No.
What happened, my lord?
Let me understand the issue.
My lord.
Initially, you have given the status of part-time.
Part-time.
Thereafter, you have given the contractual
fixed remuneration.
Contractual fixed remuneration to the part-time
lecturers
who are rendering less than 4 years. That is a fixed remuneration.
Fixed remuneration, monthly remuneration.
Fixed monthly remuneration.
Initially hourly, per hour we are getting per class. Initially before 2010, after 2010, per month you are getting a fixed salary.
Very well. That is in 2nd September notification.
Yes. Then, my lord, 29th August is the government revived engagement of part-timers, because by 2010 notification, part-timers were done away with in the polytechnics. We are all fixed remuneration. Government again engaged some part-timers.
Again engage some fresh
not the
part-timers.
petitioners, not the petitioners, but
Some fresh part-timers is required
This
to
is
be
not
engaged.
that 29th August. Fresh part-timers, they shall be engaged as per class basis.
This is in respect of fresh part-timers.
Fresh part-timers, 675.
That's why I could
My
not
lord.
understand.
It's 39. Fresh part-timers,
Hourly basis.
39 and 40. Miles.
Yes.
Then, my lord, there was a dispute regarding those who are governed by 557, whether they shall again be brought under the part-timer, these fresh notification or not. That was clarified by the government at page 41. Kindly see, this is very important, my lord.
Page 41.
41. Clarification regarding part-time appointment of teaching and non-teaching faculty in polytechnics.
Very well.
Consequent upon issuance of government order number 675 dated 29/8/2011, which is page 39, allowing engagement of part-time faculty and non-teaching faculty in polytechnics on hourly basis, a question has been raised from some corner as to whether the part-time faculty and non-teaching faculty of polytechnics who were engaged prior to July 2010 and were allowed contractual fixed remuneration in terms of department's GO number 557 dated 2/9/2010 be guided by the latest government order, hourly or not. After careful consideration, the undersigned is directed by the order of the governor to say that the part-time faculty and non-teaching faculty engaged in polytechnics prior to July 2010 will continue to draw contractual fixed remuneration as defined in the manner by this in this department GO 557 dated 2/9/2010 until further orders. However, part-time faculty and non-teaching faculty to be engaged from October 2011 will be guided by department's GO number 675.
29th August.
Petitioners prior to 2010, 557. Now, after that, if you engage some part-time, they will be governed by 675, which is page 39. So, clear distinction is also made by the government. Now, they cannot say that we are doing on hourly basis.
Very well.
Fixed remuneration. This is not the status. By these memos, this is the status conferred to us. Now, before going to the finance department circular, I have the writ petition stated how we are doing the functions of a full-time teacher from paragraph 12 onwards. Para 11 is the clarification memo. Kindly come to page 10 of the writ petition.
Yes.
Para 11, I have already placed the clarification memo that we are governed by 557 fixed remuneration, not hourly.
Yes.
12, that the nature of the duties of the petitioners and the period of engagement are completely different from that of part-time lecturers appointed pursuant to the memoranda dated 29/8/2011 and 8/9/2011. Petitioners were engaged by memo number 557. The part-time lecturers appointed pursuant to memoranda dated 29/8/11 and 8/9/11 are engaged on hourly basis, and they are not bound to conduct a stipulated class load in a week. They don't have to perform their duties other than the classes allotted to them, and they do not get paid for any public holiday. They can work at more than one college at a time and get paid by such colleges. On the other hand, the petitioners have to attend their respective colleges regularly from 10:30 AM to 4:50 PM, and they have to conduct a stipulated class load in a week. Moreover, they are allotted other duties like invigilation duty, election duty, students admission and registration duty, like a regular employee. It is pertinent to mention here that petitioners herein work the same number of hours as compared to the regular employees from 10:30 AM to 4:50 PM, or else the remuneration would be deducted. Some of the routines which have been annexed later will show that the petitioners have to attend the polytechnics from 10:30 to 4:50 like regular employees, crave leave to produce documents. Routines we have annexed, timetables, to show that we are doing throughout the day. Para 13, petitioners state that the petitioners have, since their respective appointments, in fact been rendering services at par with the service rendered by the full-time lecturers. Petitioners have in the past performed and continued to perform on most occasions duties exceeding those performed by full-time lecturers. So then, my lord, we annex a chart. Kindly come to next page, my lord. In respect of, my lord, some of the petitioners, This is a chart, my lord. Kindly see, my lord. In respect of Mr. Dipto Sen, who is the petition number 1. Number of class taken by Mr. Dipto Sen, weekly class is 9, but the regular lecturer of same discipline is 3. If your lordship compares the number of classes, Mr. Sen is taking 22 classes against 13 classes by the regular lecturer per week. This is a workload they are sharing. 2 semesters we have given. Similarly, petition number 2 also we have given a chart to show similar nature of work.
Yes.
In the opposition, they have said that you are part-time, you don't have to attend throughout the day. There may be timetables, but that doesn't mean that you have to remain in the school polytechnics throughout the day. You can come at the time of the class, which is not practicable. If I have a class in the morning and in the evening, I cannot come at the hours and go.
So what is the impugned memo?
There is no rejection order as such, my lord. They have not conferred the benefit of the memo. Then the next important document is page 141, which is the Finance Department circular, my lord, which we are not seeking benefit of. So this is regarding status. The opposition, I'll show 2 paragraphs what they have said. No specific denial, my lord. They only say you are part-time. Then page 141. This is not the claim of the petitioner. If your lordship is not satisfied regarding their status, that they are no more hourly basis, then, my lord, this 141 will apply to us. 141 is the Finance Department's circular at page 141, annexure P10. In order to provide security of tenure, appropriate emoluments and certain terminal benefits subject to fulfillment of certain conditions to the casual, daily rated, contractual workers. Kindly mark this. These are the categories who get casual, daily rated, contractual workers who have remained engaged in various government establishments for a considerable period of more than 10 years in connection with implementation of various schemes, projects of various departments of the government. While memorandum dated so and so were issued by the government in finance departments. Question of making the provisions of the 2 aforesaid orders more effective and suitable to the convenience of the government establishments, organizations has been under active consideration for the government. After careful consideration of the matter in supersession of the aforesaid orders and all other orders issued by the departments in the matter, undersigned is directed by order of the governor to say that the governor has now been pleased to order that the casual, daily rated, contractual workers who are remaining attached to various establishments of the government, departments, directorates, regional offices, other organizations for not less than 10 years continuously as on 1/8/2011 and have rendered service for at least 240 days each year will be allowed the following benefits. So this is not the conferment of the benefit. Engaged casual, daily rated, contractual and attached to various establishment of the government, departments, directorates, regional office, other organizations. Everything is covered. But they have to be 10 years as on 1/8/2011. Because they have taken this point that on 1/8/2011, most of the petitioners have not, some may have, they have not completed 10 years. That is also taken care of by the same memo. The same memo says, kindly come to 142 clause 5. Those casual, daily rated, contractual workers who will complete 10 years of service on 1st July every year will come under the purview of this order, provided no such worker is engaged after 1/4/2010 will come under the purview of this order. We are all prior to 1/4/2010. So if somebody has a shortfall of less than 10 years, the moment he achieves, he will come under the purview of this order. And this order also says, my lord, that what is the conferment? 1 and 2. Kindly come back to 141, my lord. They are giving security of tenure and security of pay. 1 is the casual, daily rated, contractual workers who have rendered 10 years of service continuously with at least 240 days attendance each year may remain engaged in the same status and capacity till they are attaining the age of 60 years. The continuity of service shall have to be certified by competent officers. This is not. Next is 2, Roman 2. And entry point basic pay in pay band 1, rupees so and so, will be admissible to casual, daily rated, contractual group D workers as consolidated remuneration. Similar entry point pay will be admissible to casual, daily rated, contractual group C worker and an employee of any other category. If he or she fulfills the required condition, will be entitled to a monthly remuneration, which will be minimum entry level pay of band pay and grade pay corresponding to his or her category. And remuneration may be determined in consultation with the finance department. So, because lecturers are not group C, group D, they are possibly group B, group B. So, in any case, group A. So, it has to be fixed. If not, they have prescribed for group D, the corresponding entry level pay has to be fixed for group C, group B, and group A also. So, what they are giving, one is not security of tenure till the age of 60 years. The other is entry level pay for the commensurate category. These are the two benefits given by this circular. And those who attend 10 years, after also, they will also get. This is not the finance department circular, which we say it covers all departments. There are some other benefits of enhancement of pay also. Clause 3 says they will get a yearly enhancement of 5%. These are there. So the crux of the dispute is
What is the memorandum of 2966 and 11749?
11749. No, these were the previous memoranda which have been superseded.
Yes.
These have been superseded. It was initially only for Milord.
What are those memos?
Those are not annexed to the writ petition. Milord. They can produce if the state produces, Milord, because these were only regarding various schemes and projects.
Implementation of various schemes and projects of various departments.
Yes, restricted to
the
schemes and
government.
projects. Para 1. Then these are superseded. Now it is not given to all departments. Initially, schemes and projects.
Second para says in question of making provisions
to
aforesaid orders.
More effective and suitable.
Yes.
To the convenience of the government establishment organization has been under active consideration. Then, after careful consideration of the matter in supersession of the aforesaid orders and all other orders issued by the department in the matter, undersigned is directed by order of the governor to say that the governor has now been pleased to order that the casual delegated contractual workers who are remaining attached to various establishments of the government departments, directorates, regional offices, other organizations for not less than 10 years continuously as on 1/8/2011 and have rendered service for 240 days. So initially it was schemes and projects. Now superseded and further benefits are given to all departments.
Will the lecturer come under the purview of these notifications?
It will, Milord, because other organizations, directorates, these are not technical education directorate, government directorate. We are coming under the second category, directorate, government directorate. This is technical education department, directorate. Directorate is the directorate. They are not disputing in their affidavit that this will not apply to polytechnics. They are saying you are part-time. 1. 2 is that there is no sanction post. Their defense, main defense is.
Yes.
We have not been engaged against a sanction post. 1 is you are not part-time, not contractual. Second is there is no sanction post. You have not been engaged against a sanction post, so you will not get the benefit of the circular. And third is you have not completed 10 years on the date of this memo in 2011. These are 3 objections. First objection that I have submitted that our nature of engagement has been changed. Second objection, my lord.
Okay, let me show the AOs.
My lord. Because it does not say sanction post. All employees engaged. Because no delegated employee will not be engaged against a sanction post.
That's why I want to see the memorandum. The 2 memorandums.
So these 2 different lordship direct they can
by
produce. They can produce, not annexed to this.
Do you have the memorandums?
No, I don't.
Mr. Debra, no.
Right now.
Let him complete first. Yes, what are the
Lord,
AOs?
kindly comes to the affidavit in opposition, my lord. And Lord, one last thing, my lord, we have used a supplementary affidavit. It was not permitted by your lordship, copy sub. Here, my lord, we made my lord, RTI application before the All India Council for Technical Education, because my lord, these bodies are all functioning under the All India body. Our status has been uploaded as contract. Kindly see, my lord, RTI replies the supplementary affidavit. The college itself is describing us as contractual from page 5 onwards of the supplementary. Page 5 onwards, kindly see, my lord, with
What is
reference
the
to your
supplementary?
RTI application. Supplementary.
Affidavit and reply on behalf of the writ petitioner.
No, supplementary affidavit, my lord. Supplementary affidavit.
Affidavit in opposition on behalf of respondent number 1.
Supplementary একটা ফাইল করা হয়েছে। হ্যাঁ, জি।
Can
এই সার্ভিস এটা দেখা।
affidavit of service supplementary. Yes. Yes.
Now, lordship kindly comes to page 5, my lord. This is a reply by the All India Council for Technical Education with reference to your RTI application dated 27/4/23 under RTI Act for furnishing the mode of engagement, appointment type of faculty ID so and so. Detail is as per AICT web portal. This is how the college has not uploaded our status in the web portal of All India Council for Technical Education. Kindly see, my lord. This is not Shapon Kumar Shah, he is one of the, my lord, petitioners. Appointment type, kindly see contract. First, second, third, fourth, sixth column, my lord. Appointment type, contract. So they are uploading our status as a contractual.
In the portal.
In the portal of the All India Council.
The
of,
web portal.
My lord. And same thing, my lord, regarding other petitioners also, the other pages I have annexed, my lord, 6, 7, 8. This goes on up to page 16. Up to page 17, my lord.
Is there any provision to make the part-time or anything?
No, my lord, there is no problem because they are uploading us by representing us as not contractual. There is no provision for part-time possible. That is why they are themselves representing before the higher authority that we are part-time, we are contractual employees. That is their representation, and it has been uploaded on record. We have stated that, my lord, there is no rebuttal of this supplementary, my lord. Serve হয়েছিল তো? স্যার কপি দিয়ে দেবো, দেওয়া আছে। And the last annexure is, my lord, the latest memorandum, page 18 of this supplementary, my lord. 2011 circular has been, my lord, modified. The rates have been enhanced. This 1st March 2024, the question of enhancement of remuneration of the casual contractual workers engaged in various government establishments in terms of memo dated 16/9/11 has been under active consideration of the government. After careful consideration, the understanding is directed by the order of the governor to say that the governor has been pleased to decide as follows. With effect from 1st April 24, consolidated monthly remuneration of the above categories of workers will be revised as follows. They have revised it, my lord, to higher. Various times they have revised. This is the last revision. This is regarding Group D and Group C. There has to be commensurate, my lord, calculation of Group B and Group A.
No, this is the only issue. No, I shall ask you one issue.
My lord.
So, where are the AOs?
My lord, kindly take up the affidavit in opposition, my lord. দিচ্ছি স্যার, সাপ্লিমেন্টারিটা দে।
Yes.
Now kindly comes to Lord, page 3 onwards, Lord, they have made out the positive case of the government. Paragraph, page 3, paragraph 4A onwards. Paragraph A, my lord, is initially how we are appointed. paragraph B, my lord, they talk about 391. Petitioners are initially engaged as part-time lecturers on part-time basis for a period of 6 months. How much we have been engaged? So this is prior to 2010. They say that we don't have qualification at par with the recommendation of the AICTE for a lecturer in humanities science, and they are not entitled to higher pay fixed for part-time lecturers having such qualification. This is also incorrect. We have denied in our reply. A copy of AICTE regulation 2010 and recruitment rule is annexed here too. Now, the question of recruitment rule will not come, because in case of equal pay for equal work, recruitment, mode of recruitment is not important, whether we have the qualification and rendering the same function or not. That is the criteria. And we have been appointed through a interview selection process.
Sanction.
Against post, against sanction post. That also we have stated in our reply. Then they give the particulars. Paragraph C, give the particulars. Then paragraph D onwards is their case, my lord. Page 6. Paragraph D, page 6.
Yes.
They have given the various dates of engagement. They wanted to show that we have not completed 10 years as on September 2011. That is why the dates have been given. Then paragraph 6D. It is contended that the policies governing the engagement and remuneration of part-time lecturers were based on rational criteria, including the need to address faculty shortage and the specific requirement of various disciplines. Remuneration structure was revised to reflect the qualification and experience of the lecturers, ensuring fairness and equity in compensation. Respondents deny any allegation of arbitrary or discriminatory treatment of the petitioner. All decisions regarding engagement of part-time lecturers are made objectively on clearly defined criteria and applicable policy. Respondents maintain that the decisions regarding engagement of remuneration of part-time lecturers were within the bounds of administrative discretion. These decisions were made considering overall operational requirement and financial constraints of the education institution. Respondents assert that part-time lecturers cannot claim parity in pay and benefits with contractual lecturers or regular full-time faculty. Nature of the engagement, duties and responsibilities are distinct from those contractual regular faculty members, and thus different terms of employment and remuneration are both reasonable and justified. This is their case. Respondents emphasize their commitment to complying the legal and policy framework governing the employment of part-time lecturers. All actions taken were within the ambit of law and aligned with the policy objectives of the educational sector. It is apparent that the part-time lecturers were engaged as per requirement of subject-specific disciplines of the respective institutions and as per the guidelines issued by the government prevailing at the relevant point of time, and after completion of each tenure of engagement, they were engaged afresh from time to time. None of the guidelines issued by the government modified the part-time engagement of the lecturers to contractual engagement. Such a claim is misinterpretation of the policy of the government, as the nature of duties of the part-time lecturers have not been equated to that of the contractual lecturers. They do not deal with the memo of 2010. That is not the main case. 557, they say contractual fixed remuneration. Now, they have not explained if it is contractual fixed remuneration, how they retain the status of part-time. This is one. If it becomes contractual fixed remuneration, it cannot remain part-time. And the second is not very important. I have shown the clarification memo. After 2010, fresh part-times were made. The question was made whether the contractual fixed remuneration, then they will be governed by the hourly basis or not. I have shown you lordship note page 41. Clearly mentioned that no, these persons engaged as per 557, they will continue to draw monthly remuneration. And the other subsequent appointed casual or part-time employees, they will get hourly basis. Page 41 is very important. Clear distinction is made. Page 41. So they have not clarified why page 41 has not been discussed at all, and page 34, 557 has also not been discussed. They only go on saying that no, you are part-time. You are part-time, so you are different from the others. So this is not the case made out. Apart from that, they have also, while dealing, they have said that yes, it is true that to cope up, you have been given other functions like regular teachers, but that was COVID times. But you are not bound to remain from 10:30 to 4:30. So you are not fixed contractual employee. That is not their stand. And the other point is sanction post and 10 years has not been attained. These are the three defense taken by them, so far as this is concerned. So, and I rely upon the judgment on equal pay for equal work, my lord. Jagjit Singh judgment are there. Jagjit Singh. 2017 1 SCC. State of Punjab versus Jagjit Singh, my lord. Here the principle of equal pay for equal work. In the opposition, my lord, they do not dispute, my lord, that we are taking the classes. Number of classes which the chart I have shown to your lordship, my lord, in the writ petition, the number of classes I am taking and a regular employee is taking, that chart is not disputed. Your lordship has seen paragraph 13, page 12, I have shown to your lordship. নিয়োজিত টিচারটা আছে নিয়োজিত আচ্ছা তো চলে গেছে তো চলছে তো তুই তো তোকে পেছনে যেতে পারবো করছি তো মামলা করে যাচ্ছি লিখে দেন Now, my lord, in 2017, the Supreme Court, in 2017, 1 SCC 148, State of Punjab versus Jagjit Singh, it has been clarified, my lord, by the Supreme Court that equal pay for equal work, it is the norm, previously held also, here also it is held. 2017, copy আছে 17 1 SCC
2017 148.
148. The paragraphs 57, 58, and 60, my lord. Fifty-seven, 58, and 60. এটা করে যাবো চোখ করছি করে যাচ্ছে বলবেন একটু শেষ করে দিয়ে যাচ্ছি না একটু কপি দিয়ে দিচ্ছি কপি করে দিচ্ছি এটা কপি করে স্যারকে দিয়ে দিতে
Yes.
So, my lord, this principle of equal pay for equal work, my lord, subsequently was followed in 2019-12 SCC.
Equal pay for equal work.
Equal pay. 1912 SCC 297. এটা কোথায় 1912 1912 SCC 297. Where, my lord, this principle is again followed by the Supreme Court. 297. নিয়োজিত তো
Yes.
Now, there is one more judgment where there is slight departure from this principle. Then the case of Niyojit teachers, State of Bihar versus Bihar Secondary Teachers Struggle Committee. Here, a small departure has been made that depending on the policy of the state, here it was held by the Supreme Court that no, it was a policy. The benefit conferred was commensurate to their work, so they will not get. So I should also produce this because if I show those two and then not the last one. But in our this 2019 18 SCC 301 18 no, 19 18 SCC 19 volume 18 SCC. Here some departure has been made, but I say not here the government's policy is to confer the benefit. 301 301.
Yes.
Here, but I have shown the memo of 2011, which says that, my lord, for same work, same pay band has to be given. So the government's policy here, as per, my lord, the memo at page 141 is, my lord, to give the same pay band. 141, I have shown your lordship, my lord, last, kindly come to 141, last paragraph. Entry level basic pay in pay band shall be admissible. Page 141, last paragraph. Last paragraph, my lord. Entry level basic pay in pay band 1 will be admissible to casual delegated contractual workers. So they are giving, my lord, the entry level pay. So far as, my lord, the all categories of employees are concerned for equal pay. But in our case, only
You're
because
referring paragraph?
paragraph Roman 2 at the bottom, my lord.
Roman
2 at the bottom, page 141. And
Entry pay scale.
entry point basic pay in pay band 1 will be admissible to casual delegated contractual group D workers. So basically, they are borrowing the principle of equal pay, and the basic pay of the regular employee is given. So this memorandum is in consonance with the principle of the Apex Code, that you have to give the at least the entry level basic pay of the regular employees, because they are discharging similar function. So these are the basic requirements of the petitioner, which has been taken care of by this memoranda, but they are not implementing, only on the ground that you are part-time. So I say that part-time, this should be extended to everybody. Government's policy should be they are giving it to everybody, even casual or daily rated contractual. Everybody is getting, and they are giving a suffix of part-time and not extending it to us. But I have shown to your lordship that the nature of engagement is not no more part-time. The term is there. The term remains like an unwanted title. But, my lord, because of that, we are excluded, my lord, from the purview. These, my lord, the sum and substance, my lord. In 2021, my lord, they have given some benefits, page 152, but that is not commensurate with page 150 or 141. 21 is at page 152, 2021 memo. These are sum and substance. If my learned friend produces the two memorandum, then I can address on that also. That was modified subsequently. All establishments.
The question is the conferment of benefit by memorandum dated 16 September 2011. The casual, delegated, and contractual workers of the departments was given the benefit. Specifically, it says the entry point would be group D entry point.
Yes, group
There is the financial benefits.
Group D entry point, but kindly go on, Lord, after that.
Group C.
Similar entry point will be admissible to casual delegated contractual group C worker and an employee of any other category.
Yes.
If he or she fulfills the required condition, will be entitled to a monthly remuneration. So group D, group C, and any other category. So they are taking care of everything. Not that only group D or group C. All employees. Any other employee. This is the sum and substance of the case of the petitioners, my lord. We are entitled to the benefit from 2011.
Now the status of your service is always part-time.
Yes,
whether it was changed,
status.
Only the status, not status has been changed. Your pay protection has been given regarding the contractual, as like contractual.
Yes.
Employees.
Contractual.
But it says implementation of a contractual fixed remuneration of part-time lecturers. That is memo number 557.
557. No, not off. Implementation of contractual fixed remuneration of part-time lecturers.
Yes. Your status being same as a part-time lecturer.
No,
not as contractual.
No, implementation
like
of contractual remuneration of we were part-time. It says part-time because we were the part-time lecturers.
Yes.
Now contractual fixed remuneration is conferred to us, to the part-time lecturers. That is why it is said contractual fixed remuneration of the part-time lecturers. So those who were the part-time lecturers, contractual fixed remuneration is conferred on them. Because these two cannot go hand in hand. If somebody is a part-time employee he cannot not be a contractual. This means two concepts are not mutually destructive. It cannot go on not hand in hand.
The memo says the implementation of fixed remuneration as contractual employees
My lord.
to the part-time lecturers.
To the part who were asked while who were holding the part-time lecturers.
So
they have
your
been given.
status of service has not been changed by this memo. You have given some financial benefits only.
I would humbly submit, Lord, I have shown, Lord, the nature of duty that we are doing part.
Yes,
that is one thing.
That is,
Other,
that is
I would
altogether
say,
separate issue.
even not forgetting that part, my lord, even if not this memo is taken, the moment not we are brought within the purview of not a contractual fixed remuneration, monthly remuneration, we are paid, my lord, for the days we are not going to college also. Kindly consider, my lord. If it is a fixed remuneration, we are paid for the 30 days of the month. Suppose 15,000 they are paying, so 500 for every day. So suppose somebody is ill.
Your submission is that when you have given the contractual remuneration, so you have to work for entire the month.
With entire month,
Entire month, not for the particular
except the
hour.
holidays. Yes, not for the my lord. I'm extremely grateful. That is not the concept. Not for our.
It was specifically
clarified
by
by page 41.
Same separate memo.
That no more. You are not hourly paid because that was the question raised.
Paid contractually.
Contractually for a month, for even for the holidays.
So that is your case. That
because in a month,
I have given the status.
My lord.
So my
during the pujas also, during the puja holidays, if the college is closed for my lord 20 days also, then also I get for that entire period. Same like in the summer, during summer vacation also, you are getting the remuneration for that period. If
Yes,
it is
Mr. Devra.
part time. Sir, may I just get back? One matter is being called, and I'll just within 10 minutes I'll come back. Let him.
Okay. When can it be done? You please come with those two memos which mention in 16 September 2011 memo for more clear clarifications. Yes.
No.
Yes, page 141.
141.
Page 141 is the memo which the
16 September.
yes, this is the memo. In the first paragraph, two memos are mentioned.
966.
2966 and 11749. 11794.
This.
Please bring those memos. Very well. Please take down matter head and part. No, and the argument on behalf of the petitioner concludes. Let the matter appear in the list on 28th.
Milord, 28, Milord, there is some problem, Milord.
Let them conclude first. 28th. Other added parties are there.
I'll conclude.
Milord, we'll keep the matter. Mr. My learned senior friend will argue the matter. I will take note of this.
Yes. Fix the matter at 28th at 2 p.m.
Supplementary affidavit. Once it was served, Milord, but on his request, Milord, we are providing again.
This supplementary.
Milord, this was already served once, but my learned senior friend said that it's not available with them, so I'm submitting one more.
I am not able to take any instruction from this.
Milord, this was served, Milord.
They are engaged with me, well, no longer.
However, you just peruse it.
18th of April.
They are engaged by the government media office, which is not with the practice.
28th. এগুলো দিয়ে দিন। হ্যাঁ। Give me the copies of these citations.
Milord.
Hey.
Argument of petitioner
concludes.
record করেছি argument of concluded next
Concludes. For the argument on behalf of the state. For the argument on behalf of the state. 2 p.m. 2 p.m. Yes.
It's a case.
I have to arrange the matters so that the matter can be disposed of today. I want the matter can be heard out from the শোনো কালকে কি আছে
My lord, let it be taken up at 2 o'clock, my lord.
2 o'clock when?
Any day, my lord, as per the court's
Now, those
convenience.
matters are fixed when? Friday.
29th, madam. We can appear with those matters, madam.
Yes, my lord.
Other date.
Oh, my lord, it cannot appear with that matter, my lord, another date is.
It can appear, I don't know why, but I'm pretty sure it cannot.
As per the instructions, my lord.
Rana's passing the order, then it's.
গুলো আছে না ফ্রাইডে ফ্রাইডে গুলো তো চলছে ওগুলো তো চলবে স্টেট ব্যাংকটাই ফ্রাইডেতে নেই ফ্রাইডে টপ করা যেতে পারে ওকে this Friday
This Friday happens, sir. Difficulty, madam. Which I didn't happen. Next Thursday, Friday, any day, madam.
Uh, 29th, I have fixed those matters. Section 34 are fixed. Then come on 28th. 28th at 2 p.m.
Yes, ma'am.
28th, these matters will be there.
Having some difficulty at 2 p.m. I have a fixed matter. In code 36 actually. 30th, madam, is subject to lordship's convenience, of course.
30th is the Friday.
Yes, my lord, 30.
আছে ওখানে দেখো তো স্টেট ব্যাংক আছে কিনা 30th
2 p.m., 3 p.m. whenever.
স্টেট ব্যাংক আছে 2 p.m. আছে
But if he passes at 3:30, then subject to lordship's diary.
My lord, Friday, it becomes
2 p.m. Okay, Friday, I have some fixed matter. However, Friday, that means 30th at 3 p.m. 30th at 3 p.m.
My lord, can it be at 2 p.m.? my lord?
2 p.m. I have a fixed matter, parted matter.
Okay, ma'am.
Otherwise, I have to engage this matter. After completion of this matter, this is a parted matter, long matter. I have heard a lot. It would be taken only half an hour like
My
that.
lord, can it be taken up in any other day at 2 p.m.?
Any other day, I have some group 8 matters.
Okay.
On the first 3 days of the week. Thereafter 2 days are group 6 matters. These are the matters arranged. That's why I fixed this matter 3 p.m.
Okay, my lord. Deeply obliged.
3 p.m. An accommodation sought for on behalf of the petitioner. করে করবে on behalf of the petitioner করে 3 p.m. Yes. Other group 2 matters. আর কি আছে আচ্ছা আপনি থাক আর কি আছে
Well, I am appealing for the state, my lord, led by Sheikh Mohammad Ghalib, my lord. দাদা
আর কোনো ম্যাটার আছে তিনটা ফিক্সড?
Lord, I am for the, my lord,
আর কোনো 3 PM ফিক্সড আছে?
for the response number 6 and 7.
জাস্ট ওয়েট। হুম, পার্টনার ম্যাটার আছে না? Yes.
Affidavits now the service is for the university concerned. I think
Today we received the copy.
the
Okay,
copy of affidavits.
Who is for the petitioner?
The petitioner is not here.
Serve the copy of pleadings upon the state as well as the university. You have received both the. Let it be fixed on Wednesday.
Earlier occasion also, my lord, petition is not there, my lord. Earlier occasion also, my lord, petition is not appeared in the matter, my lord. If I'm not wrong, my lord.
Petitioner perhaps aware about this matter, how they serve the pleadings. They are aware about this matter, I think. Let them give in one opportunity. Okay.
Time to record that we received it and time to Milord also record that in on the next day. Raise them.
Very well. Please take down. State as well as the Vidyasagar University are represented through their learned councils.
My lord, I am also appearing, my lord, for my lord, response number 6 and 7.
Respondent number 6 and 7 also represented through their learned council. Stop. The learned councils appearing on behalf of the state as well as the university submits that that in pursuance to the direction of this court on 7th of August 2024, the petitioner has served the pleadings, served the copy of pleadings. Stop. It appears that though the petitioner has served the copy of pleadings upon the respondents, but did not appear before this court. Full stop. The petitioner was also absent on the earlier date. However, as the matter is otherwise ready for hearing, and it further can be assumed that the petitioner is aware about the status of this case, status of this matter. Let the matter be fixed on 25th, 5th on 28th.
28. Next Wednesday.
Next Wednesday.
2 PM, my lord. 2 PM, my lord.
At 2 PM. For further consideration. No,
Well, may
under
I-
the same head.
Wait.
Yes.
Petitioner.
Petitioner. Yes, yes. Next Wednesday, you have served. Next Wednesday, 2 PM.
Lordship, item number 3, being led by Mr. Mukherjee is in this matter. He's on his run, Lordship.
What is the matter?
Lordship, Lordship will grant me a short passover. Lordship, my senior is on the
Today is Passover. 15, 13.
Lordship, he's on his way, Lordship. Not briefed in this matter.
Not today. Next matter.
Lord, in this matter appearing of the respondent university.
You are for the?
I am for the petitioner, my lord.
Lord, the matter is ready for hearing. Lord, the affidavits has been exchanged. Lord. The only thing, my lord, there is a, according to us, my lord, we were suspended for a period of 3 years. Now, my lord, the college, my lord, on the previous occasion submitted that, and their affidavit in opposition also shows that they are alleging that we have been expelled. My lord, to that effect, my lord, they have not filed any document. So if they want to, my lord, file any document, because I am not in a position, my lord, to deal with such document. But at the time of final hearing, my lord, kindly do not permit them.
Then why you came here? Why you came here? What is your ground of?
Kindly take.
What is your prayer in the read?
Yes, my lord, kindly takes up page 28 once.
Kindly takes up page 28.
Yes, page
20?
28.
28 is the order.
28.
What has been practiced by the
Well, these all are allegations, my lord, without producing any document. Without producing any documents, they are alleging that we have.
No, you have annexed this document.
Yes. My lord, kindly see, it is.
What is this?
Yes, this is addressed to the petitioners, my lord. My lord,
What is your name?
My name is Sanjit Ram, Ajit Kumar Yadav, Vishal Kumar. Now, my lord, what it says.
Lordship, this has been addressed to a person called Umshu Tiwari, not to the petitioners.
Yes, his name was cut.
His name was striked off. And
My lord, from the very inception, my lord, they are taking this point. They have also taken this point in their opposition, but they have not produced the actual document, my lord, which they are saying, my lord, it has been served upon us. This is the document which has been served upon us.
No, this is not the document that has been served.
But they have not produced in their opposition. They should have produced.
We will produce.
No, my lord, they should produce it by way of an affidavit.
By annexing a false document.
They should have produced that by way of an affidavit. They were granted the opportunity to file an opposition. They have filed it, but they have not produced the document.
We have said they're taken that stand in our opposition.
Well, this is the document by which, Millard, it says, Millard, this is to inform you that as per faculty resolution number so and so, you have been debarred from entering the college campus for 3 years in view of your acts of vandalism between 4th and 6th June, unbecoming of a student of Sirampur College. You are also removed from all post and / or committee of college. This decision will come into immediate effect. This says, Millard, for 3 years. Millard, this order was passed, Millard, in the year 2018. Millard, challenging, Millard, this was served upon us. Millard, challenging this, Millard, we have filed this writ petition before this honorable court. Now, Millard, already 3 years has lapsed. According to us, this is the order.
So what is your ground to challenge?
Millard, 3 years has elapsed. Millard, this order has gone.
No, Lord.
Now you admit that you have conducted.
No, Millard, I have, Millard, specifically, Millard, they have annexed a report to their opposition, which shows, Millard, that the ground on which this vandalism was caused, Millard, we were not student of that course. Certain students of commerce stream were not permitted to sit in their test due to low attendance. We are not, Millard, of commerce. We are of, Millard, arts. So, Millard, we are not aggrieved. Even then, Millard, our names, Millard, are included, Millard, in this, and we were, Millard, debarred for 3 years. Millard, now, Millard, 2018.
What you want?
Yes.
Whether the benefit of 3 years.
3 years has lapsed. Millard, let them permit.
This.
Let them permit, Millard, to complete our course.
If you want the 3-year gap, then you have to admit this. Otherwise, you have to challenge this.
Millard, I tell you, Lordship, Millard, 3 years, Millard, that order, Millard, that I have suffered. Now, after suffering, kindly permit us to, Millard, complete our course now. Because 3 years we have already suffered.
We have also craved leave here. At the time of hearing, we will produce the document.
Millard, that will not do, Millard. I have to, Millard, deal with it.
Lordship, he has annexed. He has already dealt with
documents like that.
He has already dealt with the false document.
Whether you have taken
on oath, he is saying, Lordship,
kindly
take some.
They have
document.
Lordship, he has taken the point.
They have taken the point. They have taken the point without producing any document.
We have craved leave, no, Lordship. That is a wrong statement.
Have you taken that down in the AO?
Yes.
Lordship.
Lordship, the point has been taken at page number 3, Roman 3, Lordship, para Roman 3. The AO filed by respondent numbers 4 to 10.
Yes, got it.
Lordship, page 3, internal page 3, para Roman 3.
And now, my lord, kindly see the last lines, my lord, of the paragraph. I crave leave to make appropriate submissions without any document.
Lordship, in that regard, Lordship,
Let them show an expulsion order.
I will. Lordship, kindly takes up page 12, thereafter.
No, they have stated, they have taken the ground in the AO.
Lordship, and in page
that
number 12,
you
also.
have not annexed the proper document.
So, my lord, I have not annexed. They should have annexed it. It is their document.
We will produce it before this one.
You have received it.
No.
They have received.
The thing which I have received, my lord, I have stated on affidavit.
Okay, just wait.
Lordship, kindly takes up page 12, para 10.
Page 12, paragraph
Page 12,
10.
paragraph Roman 10. Lordship. There we have categorically stated that these 3 candidates have been expelled from the college, Lordship. And there we have said that we crave leave to produce relevant documents at the time of.
Okay, you file the document.
Now, my lord, what
Sir, here-
prevented them, my lord, from filing the document with the opposition?
Nothing prevented
I could have, my lord,
Very well. I am directing to file those documents.
and kindly, my lord, permit me to file an objection to that.
Very well. Please take down. During argument, the learned counsel appearing on behalf of the respondent, you are the college.
Respondent numbers 4 to 10, Lordship.
Respondent number 4 to 10 submits that the memo which was annexed with the writ petition purportedly written page 29.
28, Lordship, 28.
Purportedly written to another person, not to the present petitioners.
Lordship.
The learned counsel for the respondent further submits that the same point was specifically pleaded in page 3 and page 12 of the affidavit in opposition affirmed by the respondent on 12th of October 12th of when the affidavit was 12th of October 2020. Full stop. Learned counsel for the petitioner submits that the petitioners only served the memo dated 9th October 2018, which was placed as annexure P3 of the writ petition. Considering the rival submissions of the parties, it would be appropriate for this court to give a direction to the respondent authority to produce the document in support of an affidavit. The full stop. The respondent authority is directed to submit the document as mentioned in paragraph 4 Roman 3 and paragraph 4 Roman 10 of the AO by a supplementary affidavit. Let the supplementary affidavit file within 2 weeks. 2 weeks. 2 weeks.
3 weeks.
3 weeks.
And will kindly permit me to file an objection to that.
The petitioner is at leave to file the exception, if any, against the said affidavit within 2 weeks thereafter. Let the matter appear in the list on 25th of September at 2 p.m.
That's great.
Grateful, my lord.
Yes.
Grateful, my lord. Respondent number 3.
Document.
So my Madam my lord, I am all of the important university grants. College. I have already pursuant to direction of this court, my lord, I have already filed affidavit of opposition on behalf of university grant. But no reply I have.
You are appearing on behalf of
University Grant Commission.
UGC.
Yes, my lord. UGC.
You filed the
Affidavit of opposition already filed, my lord.
affidavit in opposition you have filed?
Yes, my lord, I have filed.
My lord, I am
You are respondent number?
Respondent number, my lord.
respondent UGC, my lord, and state is the answering respondent, my lord. My lord, I am
UGC respondent number
Respondent
6.
number 6.
my lord,
Affidavit in reply filed by the petitioner on behalf of the respondent number 1 to 4 has already been filed.
well, 1 to 4 is the state respondent. Here, my lord, we
They
are
are the answering respondent.
yes, my lord, we are the college teachers of the state-aided government colleges, my lord, state-aided colleges, my lord, not government
It
colleges.
is heard in part, I think.
My lord,
No.
your lordship has heard, my lord, what has happened now, Mr. Ganguly is representing the state authority, my lord. There has been a change of counsel. So, my lord, this is regarding the pay revision of the college teachers. My lord, the college teachers enjoys the pay scale of recommended by the UGC. My lord, what has
That notification I have annexed, and that is applicable.
my lord, government has my lord, adopted this UGC recommendation, implemented the pay revision, but my lord, they has only omitted to say that they have adopted this pay revisions.
Where is your AO? Where is your affidavit?
My lord, can you see? একটু বের করে দেবেন এই লেখা
Yes, got it.
My lord, got it. 2018 regulation is applicable.
Regulation 2018.
Yes, sir.
So, what are you saying?
My lord, this resolution, this regulation, my lord, this
That was not followed by the state.
yes, followed, partially followed. This this regulation, my lord, regarding the UGC pay revisions regulation, my lord, this is not mandatory, my lord. This is optional. The mandatory for the central government, centrally funded universities and colleges, and my lord, for the state-aided colleges, my lord,
It is not mandatory.
state has to adopt it. But once they adopt, they has to implement it. Now, what state has done? State has not expressly stated in their
That they have adopted or not.
yes, but in the affidavit they have stated that they have implemented the pay revision as enumerated in the UGC in the light of following such pay scale. Well, then now what has happened? They have omitted they have not given the effect from 2016, and they have not given the dearness allowance as recommended by the UGC. For this, my lord, we have come before your lordship's court. My lord, there is a resolution today of 3:30, my lord. So, my lordship may kindly takes it up in the next week, next Wednesday. My
Give,
lord.
direct them to give reply to my affidavit.
My lord, my lord, there is no requirement possibly, my lord, because the answering respondent
They are
has
not
used an
intending to reply you.
Then,
You
then
are the
that should be
authority.
recorded well, and then do not want to.
Then your opposition kept remain. Your opposition is correct. They are supporting your opposition. Why
they have not said that my petition should be dismissed.
No, why should I?
then therefore, my lord,
Please take down.
বুধবার করে নেন বুধবার দুটো থেকে
State is represented. Matter is otherwise ready for hearing. The petitioner submits that they shall not use any reply against the affidavit in opposition filed by the respondent number 6.
University Grant Commission.
University Grant Commission. Let the matter be adjourned today. Release the matter on Wednesday. Next
my
Wednesday.
lord, next Wednesday
Next Wednesday.
At 2 p.m.
Yes,
grateful, my lord.
would like to.
Next.
Appearing for the university in this matter.
Mr. Dotto appearing for the state. Which for the petitioner?
I am for the petition.
Yes.
My lord, what happens, my lord, in connect for the appointment, my appointment was made. I am rendering my service without any allegation. In
What
a
is your status? What is your service?
peon.
Peon, as a peon.
As a fourth class peon.
Very well.
I am rendering my service without any allegations. In a COVID-19 period, on that time, some period was absence. But absence is made after expiry of 1 year. After expiry of 1 year, you have no power to suo moto transfer, resign my post. That is done. That is illegal. Admitted.
What they have did? What they have done? What the college authority has done?
Terminated was made, reinstate this matter.
No. Termination order was passed.
No order, termination order was passed.
Where is the order? What order? Termination of your service from post of junior peon of Vidya University with immediate effect. Place 29. Place 21.
29.
Huh?
July 2021. Order of termination. At page 29 of the writ petition. No, at page 29 of reply, I think.
Opposition reply complete, fixing any date for hearing.
Oh, this is the order of university.
University. Vidyasagar University.
19/7/2021.
Here is for resumption of duty post termination. That is this prayer.
No, this is not the case. You are absent. You are terminated due to the pendency of some cases. Some criminal cases were there.
Criminal case, normal bail has already been sanctioned.
Bail may be given there. Bail is not the issue.
Not that is.
Whether your conduct is touching moral turpitude or not.
Well, page 21,
No,
section 440.
the memo says that you are engaged in Kotwali PS case number such and such. 260 of 2021 under section 507, 509, adding section 440, 426.
426. 427, 384, 387 IPC. Further that the matter regarding your joining was further placed before the Executive Council of Vidyasagar University in a 6th meeting held on 30th June 2021, wherein I am not suspended, nothing.
No, how can be suspended like that? How can be terminated without due process? Without due process, how one person can be terminated?
Lord, during probationary period, Milord, the university rules is that if the service
He is not the probationer, he is the permanent employee.
No, he was a probationer. And
He is
within
the
the
probationer.
during
1 year.
one year,
One
and
year.
only one day he joined the university. Only one day. During one day.
Probationer or permanent employee?
Probationer.
Probationer can be terminated.
Yes, and during probationer,
No,
he
I
was
think it is
Professional is over 1 year.
within probational period, he was terminated from service.
Okay.
No.
Very well, I understand. That's why. You say you are the permanent employee. You are not the permanent employee.
Yes, only the engagement was made for a 1 year. 1 year is over.
So probational period has to be over by
On that period, not terminated. After expiry of 1 year, terminated.
Very well.
29 June 2020 appointed.
Get ready of this matter?
No.
No, get ready. When can you argue in this matter?
আপনি কখন argue করতে পারবেন?
Adjourn for a week.
For a week, Wednesday I have fixed several matters. This matter usually take up on Wednesday.
My lord, next Wednesday at 3 p.m. I have 4 hearing matters fixed
Very
before
well. Come
another.
on then 4th of September,
4th of September.
2 p.m.
Yes.
4th of September, 2 p.m.
My lord, all pleadings are complete. Lord,
Okay,
kindly.
please take down. University, Vidyasagar University, as well as the state of West Bengal are represented through their learned councils. Petitioner is also present. Matter taken up for consideration. Let the matter be fixed on 4th of September for argument at 2 p.m.
Your Lordship, the next matter is fixed today at 2 p.m. Next weekend, my leader will not be there. If that could also be kept on the 4th of September, at 2 p.m. my other side is here.
No, I'm appealing
Item
for
number
the
7.
item number 7, my lord.
Which matter?
My lord, this is a second appeal with regard the point of
This is
law
the second
was
appeal.
second
Yes,
lordship,
second
and
appeal, I
the
understand.
point was whether, my lord, the property how it will devolve
To the women of the
on,
family.
my lord,
Second appeal. Second appeal 7. Second appeal to বুধবার কাটা গেছে।
And there are 2 cans pending here, Lordship.
ফ্রাইডেতে রাখার কথা ছিল। Okay. So when can it be done? 4th.
Lordship, only next
4th, my lord.
Wednesday, my leader is not here. So subject to your Lordship's convenience.
4th, will come back before your lordship. My lord, may I only pray for this. This will take some time. So, my lord, 4th, if your lordship is pleased to keep it at the top of the 2 p.m. list, my lord, then, my lord, because I understand there are 4-5 matters, my lord, which are fixed as 2 p.m.
Yeah.
So because the only difficulty that I'm facing on the 4th, my lord, is I have to leave for Delhi in the evening. I do not know my lord, what time I need to leave. If it is kept at 2 p.m., my lord, we'll come and argue it for an hour, my lord, on that day.
Then 5th.
5th, my lord, I'm out of town because
Out
4th,
of
I'm
town.
leaving for Delhi, my lord.
Third, if it's convenient for your Lordship.
No, 3rd.
Then Lordship, keep
Your
it at
lordship may
4th
keep it on the
2nd.
4th, my lord.
At 2 p.m. we'll take
At 2 p.m., if it can be the first matter, my lord, then we'll come and argue this point.
This matter you've taken up on 4th. This is just earlier matter.
The previous matter, my lord.
Yes, just previous matter.
Then, my lord, may we come back on the next week? But it will only
only 6th থেকে কিছু একটা আছে কি আছে 6th থেকে
11th.
11th
11th we can be before your lord.
11th at 2 p.m.
11th at 2 p.m.
11th at 2 p.m.
I'm very deeply obliged.
11th at 2 p.m.
Grateful, Lordship.
Yes. These are the pattern matter. I have to conclude these matters. But Thursday is not possible for you. Thursday is not possible for you.
Any day, my lord. Any day.
Come on 11th at 3 p.m.
My lord.
Wednesday.
11 at 3 p.m.
11 at 3 p.m. Item number 12 and 13.
12 and 13.
11th of September at 3 p.m.
I will inform the other side.
Yes. কি হয়েছে আপনার বলো
আমার রাইটে ছিল 120 ইউনাইটেড ব্যাংকের অ্যাপ্রোচ আমি জানি না আমার লিস্টে শুধু কালকেও আমি এসেছিলাম আমি জানি না
না লেখা আছে আপনার লিস্টের প্রথমে লেখা আছে কবে ধরা হবে কালকে ধরা হবে প্রথমে কালকে ফার্স্ট
2 নম্বর
গ্রুপ 6 শুধু বৃহস্পতিবার শুক্রবার শোনা হয়
আমি জানি না আমি কালকেও
না
এসেছি
লেখা আছে আপনি দেখে নেবেন একটু ফার্স্ট পেজে লেখা আছে কবে আপনার ম্যাটার ধরা হবে একদম ফার্স্ট পেজে
আমি দোকান থেকে জেনে নিলাম না
ফার্স্ট পেজে লেখা আছে
মানে কালকে দুটো
কালকে আসুন
থ্যাংক ইউ